saying, provide me with this.
Right.
And then I have to do the legwork to it.
So we get that all the time.
Are we releasing this person? No, I agreed to a restricted custody order, it's all set out. Yeah, let's not release him, thank you.
Once again, they find it easier to email you and get you to hand serve or whatever they want rather than them go get it.
And then they lose their mind, like, I don't know if the judges are gonna follow this, and I'm like, well, statutorily they have to, so. It's a you problem, Lauren problem. It's. Oh. Oh. Right. You need to experience here. Yes. Here are ones for today. For payment PowerPoint, but these are not all for to read. So here's yours Monday. And make it and link it to this PM, so when you open the PowerPoint, I'll just fold it in through. And then just the markers.
This up and running.
All right, Ms. Rivers, are you ready? Let's get on the record in State versus Reynolds. It is Friday, November 1. Welcome to November, everyone. It's now a 2-month-long trial. We have both our prosecutors here, Mr. Shepard and Mr. Reynolds are here, and we have all our jurors. Ms. McCauley, anything we need to talk about before those jurors come in?
Not this morning, thank you, Judge.
Okay, Mr. Shepard, anything?
No, Your Honor.
All right. You, Ms. McCauley, had offered the tantalizing possibility that we might be able to shift a witness or two from Monday to today. But understandably, you needed to check and maybe cajole. Were you successful?
I've been able to get 2 witnesses that we had scheduled for Monday to come today.
Great.
One is relatively short, the other is a little bit longer. He will need to be here this afternoon,
Okay,
but I did arrange to have him here.
good. We're offloading Monday either way, short or not short.
Yes.
Would it be possible to get who those are?
Sure, so Natalie Bruner will be here today and Ronald Sluss.
Oh, okay.
Yeah.
Okay, then if there's nothing from Mr. Shepard, then why don't we bring the jurors in?
So if I'm understanding. Oh, well,
Sorry.
go, everything's down to Costello plus those 2 today, then go down minus
No,
those.
Costello's not doing that.
So starting with Costello,
Is Friday.
except for the 2 you just said,
Mhm.
so, and then the 2. Excellent. Great news. Okay. That means if you want to testify.
All rise for adjournment. Well, no, show that. President of the County Board.
Thank you, Deputy Gordon. Everyone else can be seated. Happy Friday, ladies and gentlemen. Thanks for being here on time, ready to go. Hope everyone survived Halloween, whether you were out trick-or-treating or hiding from the kids or whatever. We are ready for the second day of the presentation of evidence. We're still in the state's case. It sounds like that's what we'll be doing the rest of today as well. Things could change, but the state has witnesses. They'll probably take us on into Monday. And so with that, Ms. McCauley or Mr. Jordan, if you could call the next witness, please.
State calls Ms. Kenisha Mundy.
Face me and raise your hand. You swear affirm that testimony you'll give the truth, the whole truth, nothing but truth of God.
Yes.
Put a check on.
Mhm.
Can you state and spell your name for the record?
Kenisha Mundy, Kenisha, last name Mundy, Mundy.
Good morning, Ms. Mundy.
Good morning.
How are you currently employed?
McDonald's,
And what is your role or title at McDonald's?
assistant manager.
And how long have you worked at McDonald's?
15 plus years.
Okay. And what location of McDonald's branch do you currently work at?
Jacksonville Airport.
Okay. And
Jacksonville as in Florida?
No, Jacksonville, Hartsville, Jackson, Atlanta Airport.
Hartsfield, Jackson.
Mhm.
Got it.
and did you work at any other McDonald's locations prior to working at the Jackson Hartsfield McDonald's?
Yes, 1203 Virginia Avenue, East Point, Georgia.
Okay. And while you worked at the East Point, Georgia McDonald's, did you have the occasion to work with a Michael Reynolds?
Yes.
Do you recall how long you worked with Michael Reynolds?
The same amount, from 2010 until 2024. I mean, until I got switched over to the airport location.
I asked that question poorly. How long did you work with Mr. Michael Reynolds?
10 years plus.
Okay. Now, the McDonald's where you worked at with Mr. Reynolds, what was his role or responsibility at McDonald's?
At the time, he was a maintenance person.
Okay. And what did that include?
Cleaning, oil, changing the oil, basic detail cleaning.
And if I may direct your attention to June of 2017, or in particular, June 8th of 2017, do you recall encountering Mr. Michael Reynolds on that day?
Yes.
Okay, can you, how did you encounter Mr. Reynolds?
Well, he came in that morning. He was like, "Miss Kenisha, can I go downstairs to get my charger?" I said, "Yes," and that was it. He went downstairs, he got his charger, he left.
And do you recall, I know it was 7 years ago, but do you recall what time Mr. Reynolds arrived?
We could have been around 8, 9-ish, maybe a little bit earlier, like something like that.
Okay. And if you were to estimate how much time Mr. Reynolds was there, how much time was it?
Maybe 5, 10, not even, it's just 5 minutes, maybe.
Okay. If I may have 1 second, Your Honor.
Yes, sir.
Ms. Mundy, do you recall Mr. Reynolds' demeanor when he arrived on June 8th of 2017?
The usual. He's always the same. Quiet, I mean, nothing unusual. He's always the same person.
And do you recall where Mr. Reynolds' charger was located in the McDonald's?
Downstairs in our basement, we have like a crew room downstairs.
No further questions at this time, Your Honor.
Mr. Shepherd, do you have any questions for Ms. Mundy?
Yes, just real quick, my charger, you mean cell phone charger?
Yes.
Oh, thank you.
Mm-hmm.
I assume that's what you meant, but
Yes.
thank you. Nothing further, Your Honor.
Mr. Jordan, any follow-up?
No redirect.
Okay, questions from the jurors? Okay, take your time. Thank you. Ms. Mundy, do you recall if Mr. Reynolds was scheduled to work a full shift on that day you were just asked about, where he came in and charged and then left?
No, he was off.
He was off that day?
Yes, sir.
Okay. I'm sorry, I didn't mean to interrupt.
He had worked that night, I think. He worked that night. I guess.
Before?
Yes,
So were his hours typically in the day
In the
or
day.
at night?
in the daytime.
But sometimes it shifted around? Yes?
Yes,
Okay, so your recollection is he had worked the night before?
yes.
And then he came in just to charge his phone,
He came in to retrieve his charger.
retrieve his charger,
Mhm.
and that was it?
That was it.
Okay, it's not that he skipped his shift that morning?
Correct.
Okay. Mr. Jordan, any more questions for Ms. Mundy from the state?
No, Your Honor.
Mr. Shepherd?
No, Your Honor.
All right, ma'am, thank you for being here.
Oh, no problem. Have a good day.
You too. Next witness?
Your Honor, City Council Kathy Bryan.
Will you sit and face me and raise your right hand? You swear affirm the testimony you will give the truth, the whole truth, and nothing but the truth, so help you God. So I ask you. Can you state and spell your name for the record?
It's Kathy Bryan, CathyBryant.
Good morning, Ms. Bryant.
Good morning.
Ms. Bryant, how are you currently employed?
McDonald's.
And what do you do at McDonald's?
I'm an auditor now, operations auditor.
And have you always held that role, or did you have another job at McDonald's?
I had another role,
What was your other role?
GM,
What is a GM?
General manager of the restaurant,
And was there a particular restaurant that you managed?
1203 Virginia Avenue.
And when were you the GM of that location?
For 32 years, I ran that location.
Okay, so a little bit of time.
A little bit of time, yes.
Okay. So as a general manager, what are some of your duties and responsibilities in that role?
To hire, recruit, train, run operations.
Are you in charge of all the staff at that location?
I am.
And so when someone has to like call in or ask for a schedule change, is that something that they would discuss with you?
Either me or my first assistant,
And who was the first assistant at that time?
Kenisha Monday.
Was there a second assistant?
It wasn't.
What about Shaquilla Duffy?
Yes, she was one of my swing managers, yes.
So she was another manager?
She was. Mhm.
And when you were general manager at 1203 Virginia Avenue, did you have the occasion to supervise an employee by the name of Michael Reynolds?
Yes,
Did you know Mr. Reynolds?
yes.
How would you describe your dynamic with him?
Oh, we were pretty close. I was like the mother of the restaurant and he was more like a son to me.
So when you say you're the mother of the restaurant, explain what you mean by that.
I was like that work mom, you know, try to keep him on the right path, talk to him about personal issues and those things like that. Just lead them in the right direction. They could always come to me.
If they were in trouble or something had happened, what would be your role as kind of their work mom?
Well, first it would go through like Kenisha, because I'm not really like a touchy-feely person. So when they brought it to me, that mean that it had to be something serious at that point.
If they were kind of not doing what they're supposed to be doing, or maybe something was amiss with them as an employee, were you kind of known to get on their case a little bit?
Yes.
Or mother them?
Yes.
And I want to direct your attention to June of 2017. Were you the general manager in that capacity in June of 2017?
Yes.
And was there a day in June of 2017 in which you spoke with Michael Reynolds about a scheduled shift? Or he called in?
I can't recall that.
Okay. Specifically referring to June 8th of 2017. Was Michael Reynolds scheduled to work that day?
What was that day?
June 8th of 2017?
No, the particular day.
It was a Thursday.
Yes, he would have been scheduled to work on a Thursday, yes.
What was his normal schedule?
He would normally be off. Truck would come on Wednesday. Maybe like a Tuesday or something, maybe Monday, Tuesday, I'm not sure.
Okay. Prior to coming to the board today, did you review any records or documents related to Mr. Reynolds and his schedule at McDonald's?
Yes,
And did you provide those records to the Leal Police Department?
I did.
I'm gonna show you what's been marked as State's Exhibit 10. You take a look at it and let me know if you recognize it.
Yes, ma'am.
What do you recognize State's Exhibit 10 to be?
This is the printout that was requested for me.
And did you provide that printout?
I did.
And are those records maintained by your system?
Yes,
And can they be altered or deleted once they're in the system?
it can be.
Do you know if those records were altered or deleted in any way?
I know because it would have a normally like an asterisk, or it would have the person that actually did any changes to it. It would have their card number.
And records like that, are those kept in the normal course of business for McDonald's?
It is.
During this time, the state would tender State's Exhibit 10 into evidence.
Can I look at it briefly?
Sure.
Sure. Sorry.
Just give me half a second to make sure it's what I have in my file.
Have to.
Yeah, that's. No objection, Rob.
All right. States 10 is admitted.
Okay. Just a screen share. Okay, so is that State's Exhibit 10 in front of you, there, Ms. Bryan?
Yes.
Okay, I'm gonna see if I can actually make it.
Stay muted.
Stay muted.
There you go.
Sorry, that was blocking you.
I'm actually gonna try a different way to do this because I think that's too small to be seen on the screen.
While she's doing that, I have a question for you. I believe your testimony was that Mr. Reynolds was scheduled to work that Thursday, which would have been June 8th. What would his shift have been? Ballpark, I mean, is it at night? Is it during the day?
Oh, no, it would have been during the day, definitely. He never worked at night, yes.
Okay.
So I'm sorry, Ms. Bryan, he didn't work at night?
No.
Okay, So up here, I think this is a little bit better. It's definitely clearer than the other version I had up. What were his normal work hours at that time?
It would have been 9. He said he had it at 7, and then we did a schedule change for him. I think he had picked up a job or something like that, but then he started coming in at 9.
And he would normally be there, it looks like from this schedule, 9, 9:15, 9:04, something like that.
Yes.
And he would primarily be a daytime shift person?
Yes.
And the evening of June the 7th, did Mr. Reynolds work that day? Based on the schedule, in the evening hours?
No.
What were his hours on that day?
9:07 to 3:04.
Okay. And then he was scheduled to work on the 8th. Do you see an entry here for the 8th?
There is not.
Do you know why he did not show up to work on the 8th?
I think that would be hearsay if I.
Did you speak to him on the 8th?
Did I speak to? No.
Did you review any footage of him on the 8th from the inside of the McDonald's that you were at?
I don't know if it was not on the 8th, no.
Was it another day?
Yes, it was another day.
Did you interact with Mr. Reynolds on June 9th?
I possibly could have, yeah. Yes.
Is there an interaction that stands out to you as memorable around that time?
If my memory serves me correctly, I think he had come in, it's kind of like disheveled and stuff like that. A cool person came and got me and told me that I needed to talk to Mike. And I was like, talk to him about what? And it was like, I just think that you need to come and talk to him. And so I think we went outside and we sat on the curb and I was asking him, like, what's going on, Mike? Because by this time they had already told me what the situation was and those things like that. But he was just like disoriented.
You said they already told you about what the situation was.
I'm gonna object proactively that you might be getting into some hearsay based on the nature of that question.
Okay, fair point. We have a witness who seems pretty savvy about hearsay. So ask your next question and we'll see where we go.
Thank you. Were you aware that Mr. Reynolds' girlfriend's daughter had passed away at that time? Is that the event that you're referring to?
Yes, yes.
One moment. Nothing further, I'll pass the witness.
Mr. Shepherd, questions for Ms. Bryan?
Yes, I could have the exhibit.
Okay, it's right here.
Maybe you could just leave it up for a few seconds. And round it out so that you can see more of the hours, please, if you could. If you could scroll down a little bit so that this word is kind of right there's perfect. Okay. Hi.
Hi.
Good morning.
Good morning.
So do you work at corporate now in Atlanta?
No, corporate, still franchise.
Oh, you're still with the franchise?
Yes.
Okay, so at your restaurant, when you were the general manager, did you ever have issues with turnover?
Quite a bit.
Employees that you just had to keep replacing?
Somewhat.
Okay. And how long do you think Mike worked at that franchise?
I got Mike when he was still in high school, and all that time he worked with me.
Okay. So would you characterize him as a short-term employee, a mid-term,
No.
a long-term employee?
Yes.
Okay. And looking at this schedule, it appears that he typically worked Monday to Friday from 9 to 3.
Yes.
Because you can see that it's, if you look at the other weeks, it's 12, 13, 14, 15, 16, all basically 9 to 3 with some variations. Okay. And then 19, 20, 21, 22, 23. basically 9 to 3 with some variations. Is that accurate?
That is accurate.
And then 26, 27, 28, 29, 30, basically with some variations from 9 to 3.
Yes.
Okay. Did he show up for work on June 9th?
Yes.
At what time?
9:03.
And did he leave around 4 maybe?
3:56.
3:56. Well, 3:56 is close to 4, right?
3:56.
Okay. So a few minutes before 4.
Yes.
Okay. And then the next week, it looks like he may have been late on the 12th, but it looks like he stayed till 4.
Yes.
Okay. And then he worked every day that next week?
Yes. According to yes.
Okay. And then the week of the 19th, did he work every day that week?
According to this, yes.
And the week of the 26th, did he work every day that week?
Well, it only goes down to the 28th. I can only see the 28th.
Oh, can you scroll down just for 2 seconds and then scroll back up? Thank you.
But yes, he.
Okay. And did he continue to work at McDonald's until he was prevented from continuing to work at McDonald's by an external event?
Yes.
And he kept showing up for his shifts?
Kept showing up. Yes.
Okay. As general manager, were you made aware when employees did not show up for work?
Yes.
Okay. And at your McDonald's, is it uncommon or atypical that every now and then an employee has something that they have to do or that occurs that they need to call out from work?
Yes.
Is that common?
It is a common thing. And if they did call out, it may be something that made sense
Okay.
for me.
Okay. Now, without going into anything anybody else said to you, but is it your remembrance today that Michael's reason for not showing up on June 8th did not make sense?
No.
Okay. So based upon your remembering that, at some point you learned at the time when an employee didn't show up for work.
Yes.
And then you would say, make a decision, does that make sense or not make sense?
Right. I would always question what it was.
Okay. So based upon your standard procedures, if an employee excuse for not appearing for work did not make sense, would there be something that you would do, maybe sit them down, talk with them, write a report or something along those lines?
I would definitely talk to him.
Okay, and that's something you would remember.
That's something I will remember, yes.
Okay, so the best you remember today is the reason why Mike gave for not showing up for work on June 8th made sense at the time.
Well, that would have been hearsay. Because somebody told it to me.
I understand, but I'm asking you did, and without.
Oh, yes, absolutely.
It made sense.
It made sense, yes.
Okay, and then he showed up for work the very next day, pretty close to on time.
Yes.
Okay. Give me 1 second. Do you need this further?
Yeah, I will.
Okay, I'll leave it to you. I'm done with that for now. I have nothing further.
Any redirect?
Just briefly, right? Ms. Bryan,
Yes.
Would, taking a sick child to the doctor be a reasonable, excuse to miss work?
Yes.
What about wanting to learn routes to drive for a Lyft or Uber service? Would that be a reasonable excuse to miss work?
No.
And I just want to go over the schedule with you just one more time. So this 6/5, this is a Monday, right? I think if 6/8 was a Thursday, then that would be Monday.
Okay.
Would that be accurate?
Yes, if that's what it is. Yes.
Okay, so he showed up for work on Monday, showed up for work on Tuesday, showed up for work on Wednesday, no Thursday, but then shows up again on
Friday, looks like he had Saturday, Sunday off, and then shows up again Monday, Tuesday, Wednesday, Thursday, Friday. Again, it looks like he had Saturday, Sunday off, and then Monday, Tuesday, Wednesday, Thursday, off on Friday, but then shows up Saturday, and then has a couple off days and then works the rest of the month. Is that accurate?
That, yes,
Okay. So he would normally have shown up on a Thursday.
yes.
All right, thank you, nothing further.
Any follow-up, Mr. Shepherd?
No.
Questions from the jurors? Oops, don't skip people. Thank you. So council, if you will join me, we're going to talk about these and we'll be right back. Everyone be at ease. Yes. Principal's hallway. Full ample. Yeah, it's not ADA compliant. Ms. McCauley, if you could put exhibit 10 back on the screen, please. And while she's doing that, Ms. Bryan, could you share with the jurors what you and Mr. Reynolds discussed You said you were on the curb talking with him. Tell the jurors what you remember about what Mr. Reynolds said and you said and what that exchange was.
I just, I asked him what was going on, and I was like, I know now, like that, and he was just like, Miss Cat, I ain't doing anything, and I was like, Mike, tell me the truth, and like that, and then, I looked at him, I was like, look at you now, I said, what's wrong with you, like that, so you been doing pills, because they already told me. By this time, I was getting agitated with him and stuff. And then he was just like sitting there. He was like, I don't feel good. And stuff. And I was just like, you need me to call somebody? Whatever, you want me to call the ambulance or something like that? He's like, no. And I was like, come on, Mike. I said, tell me the truth. Tell me the truth right now. Like that. And he was just like, oh, Miss Cat, I ain't do it. Miss Cat, I ain't do it. And so I said, all right. And I just got up from the curb. I went back in and I told the crew people, he's good. He says he's good and stuff like that. And then shortly after that is when they was like,
well, don't go into what the crew said.
Right.
This is just whatever Mr. Reynolds said to you and you said to him. That's it? Okay. If you look, Ms. McCauley, if you'll scroll up, please, or down, I don't know what the technical term is. We need deeper. Oh, no, yeah, a little further. No, 26 is on there. I'm sorry. Question, you'll see an entry there for June 26th. And it is like a round trip. That's my term. It's not a technical term. 1541. So 341 in and out. What does that signify?
It indicates they clock right in and immediately clock right out.
Okay. And do you today have any recollection as to why something like that would happen?
No.
Okay. Ms. McCauley, do you have any follow-up with Ms. Bryant based on what she just discussed?
No, Your Honor.
Mr. Shepherd?
Yes, I do. Okay. So at some point you have concerns about Mike's appearance and he looks disheveled. Is that correct?
Yes.
And so you go outside to try to find out what's going on.
Yes.
And at this point, you have already become aware that Mackenzie, his girlfriend's daughter, has died.
Yes.
Are you aware at this point that the police are investigating Mike?
No.
Okay. And basically at this point, you're asking him to tell you the truth about what happened.
Yes.
And he keeps saying, if I can say this, I did not do anything.
Yes.
Over and over again.
Yes.
Okay. And you keep saying, tell me the truth, tell me the truth.
Yes.
Okay. Then you were about to say, shortly after that, and I'm not going to ask you to say what anybody else told you.
Yes.
But what happened shortly after that conversation?
I just went back in the building.
Okay.
Yes.
Okay. How long after this conversation did you ever become aware that Mike had been arrested?
Yes.
Okay. How long after that conversation was he arrested?
I couldn't recall that. It was maybe like a couple weeks, maybe a week or so. I'm not sure on that one.
But at the time of the conversation, you were aware that he was being investigated?
No.
Not that?
No.
But you knew what had happened with Mackenzie?
Yes.
Okay. And just to sum it up, so you're asking him what's going on, and he keeps saying, I did not do anything.
Yes.
Okay. And just going back to this chart up here,
Okay.
Is it uncommon that on days people have personal things they need to do where they need a day off their normal schedule? Is that uncommon in the McDonald's that from time to time parents need days off?
It's not uncommon.
Okay. And so if an employee is taking too many days off for too many reasons that don't make sense, what ultimately could happen to that employee?
I would eventually take them off the schedule, give them time to do whatever matters that they have together.
Okay. Is it possible that an employee who takes too many days off for too many reasons that don't make sense could lose their job?
No, you wouldn't lose your job.
Okay. But they would get some form of removal from the schedule.
Yes.
Okay. Prior to the date when when Mike was no longer able to appear for work for reasons beyond his control, at any point, did you take him off the schedule in this time period?
No.
Okay, so it looks like in the month of June, he might have missed 2 days. Is that correct? The day where he clocked in and out, and then June 8th.
Yes.
Okay. And is that an excessive amount of what I call call out?
No, that's not a excessive amount.
Okay, all right. Thank you. Nothing further.
Just do a brief redirection.
Okay.
Questions? Okay. Ms. Bryan, from your best recollection of your memory, the conversation that you had with the defendant on the curb, was that, from what you can recall, closer in the month of June, or was it closer to December of 2017?
That was June. The weather was still good. It was in June.
It was in June?
Yes.
Okay. And just to verify, you were not aware of any criminal investigation on the
Oh, no, no,
Was it mentioned to you that he had spoken to the police?
no.
All right. Thank you so much.
Mr. Shepherd, anything else? All right, ma'am, thank you for being here.
No problem, sir.
We don't do a phase 2, sorry. Okay, thank you, ma'am. We'd be here forever if we did. All right, state's next witness.
State calls Timothy Jordan.
Praise me and raise your right hand. One sit. Do swear affirm testimony you will give the truth, the whole truth, nothing but the truth, so help you God. Yeah. Do it now, see. Put it check forward. Can you say and spell your name for the record?
Okay, Timothy Jordan, TIMOTHY JORDAN.
Morning, Mr. Jordan.
Good morning.
Mr. Jordan, you was someone by the name of Michael Reynolds.
Yes, I am.
How do you know him?
Mike is my friend.
When was the last time you spoke with him?
It's been a minute.
More than a year?
Not more than a year. It might have been like 8 months.
How do you guys know each other?
I grew up with Mike.
You say you're a friend, but you consider him a close friend?
Yeah, I consider him a close friend.
I'm gonna direct your attention to June of 2017. Were you close with Mike during this time period?
Yes, I was.
How would you describe the type of friendship that you had? Were you seeing him every week, talking on the phone? Describe that to me.
No, the relationship was like, we'll just talk on the phone every now and then.
You said every now and then?
Mm-hmm.
So that can mean different things to different people.
Okay.
What does that mean to you?
Like,
Like
Yeah.
once a week, once a month, when
probably-
things pop up?
probably like, every 2 weeks.
Every 2 weeks?
Yeah.
Okay. And back in 2017, June, what type of work were you doing?
Warehouse work.
And were you familiar with where Mike was working at that time?
Yes.
What was your understanding of where he was employed?
McDonald's.
And I specifically want to direct your attention to around the first week of June, so maybe June 6th through the 9th.
Okay.
Do you recall speaking to Mike that week?
It's been so long, so I mean, I think so.
Okay. Do you think you spoke with him just, infrequently every 2 weeks, or do you think it was more frequent?
I definitely don't remember, like, if it was.
Do you remember talking to Detective Smith from the Atlanta Police Department about conversations with Mike?
I don't remember, it was 7 years.
Okay, that's all right. It helps to refresh your recollection if I showed you a transcript of your conversation with Detective Smith.
Yes, you can show me.
So it starts here.
Okay.
Just moving through to about there.
Okay.
If that helps you.
Okay. Okay.
Does that help refresh your recollection?
No, I mean, yeah,
Okay.
a little bit.
Let's just walk through it a little bit, okay?
All right.
Okay. So, you said that, we're talking to him infrequently, maybe once every other week.
Mhm.
Okay. Do you recall a conversation with him on June 8th, 2017, you talked to Detective Smith about?
Okay. Mhm.
Yes?
Yes.
Okay.
Okay.
What was the nature of that conversation?
It's just a regular conversation.
What is a regular conversation?
Like when you're talking to your friend, it's just a normal conversation. Like, oh, hey, how you doing? What you got going on? Or, a regular conversation. A regular conversation.
Well, a regular conversation can mean different things to different people, right? So me having a regular conversation with my mom is maybe just telling her, hey, I'm still alive and breathing. Sorry, I haven't texted in a minute, but I got your package, thanks for the cookies. And it can also be, hey, I'm coming into work at this time. Can we meet about this? Those are two different things, right? Okay. Is that yes?
No, but
Okay.
go ahead.
Okay. So do you recall having a conversation with Mr. Reynolds around 8:45 that morning?
Yes.
Do you recall that he told you that he was working at McDonald's that day?
Yes.
Okay. Did he tell you in that conversation that he was sitting at a travel pilot and logging hours for Uber?
No.
Did he tell you that, that day that someone had passed away?
Yes, he told me. I think he told me someone that's passed away.
Okay. Do you recall if it was during that conversation at 8:45 in the morning?
No,
So you don't recall if it was that conversation at 8:45 in the morning? Was it the conversation that you had with him at 9:09 that morning?
I don't remember.
Okay. What about the conversation that you had with him at 9:20 that night? Do you recall that conversation?
No, I don't recall none of those. It's been 7 years. Come on.
Right.
Yeah.
Well, no, Mr. Jordan, be honest with me. Someone dying, a child dying is actually an important topic.
Don't talk over each other. Let her finish.
I'm gonna object to badgering and argumentative.
Okay, we're not to badgering yet, but let's get to the question part.
Okay. Would you agree with me that a child passing away is not a everyday conversation?
No, it's not an everyday conversation.
So that would be an important conversation.
Right.
Okay. So you don't recall having that conversation with the defendant?
No, I don't.
Okay. Do you recall a conversation that lasted at 9:19 for about 8 minutes, 9 minutes that night?
No, I don't. I'm sorry, I don't.
It's okay. What about on the 10th, on the day that follows? Do you recall having a conversation with him then on June 10th?
No, it's been 7 years. I don't
Okay.
remember this. Like,
What about on June the 11th? Do you recall having a conversation with him then?
no.
Multiple phone calls on June 11th.
I mean, yeah, but I'm saying it's been 7 years. I don't remember what happened, like what we was talking about.
It's okay. So that's why I'm asking, but I have to ask you about every single call.
Right.
Okay. What about on June 12th? Do you remember that conversation?
No,
What about June 13th? Do you remember that conversation?
no,
What about on June 15th? Do you remember that conversation?
no.
So would it be fair to say that if your phone number shows up more than just once every 2 weeks in the defendant's cell phone records, that perhaps you were talking to the defendant more frequently during this time? Would that be fair?
Yes, that would be fair.
Would it also be fair to say that in the month of June of 2017, that it would be fair that the defendant talked about this child passing with you?
What day was it?
It was June 8th of 2017 that the child passed.
I don't remember.
Okay.
Like,
Okay.
yeah. Okay.
All right, I'll ask this.
Mr. Shepherd, do you have questions for Mr. Jordan?
Yes, I do. Hey, how's it going?
All right.
On June 8th, 2017, do you remember what you ate for breakfast?
No,
Are you sure?
I'm positive.
Wouldn't what you ate for breakfast on June 8th, 2017 be important?
Yes,
Okay, okay, but you don't remember,
I don't.
okay? Do you have normal memory skills of a normal human being?
I do.
Okay, now. So based upon the state's questions, it's clear that you were having telephone conversations with Michael Reynolds in June.
Mm-hmm.
Is that correct?
Yes,
Okay. And did you continue to have telephone conversations with him periodically at whatever level for the rest of the year, that year, 2017?
yes,
Okay. And during those telephone conversations, were y'all talking about stuff?
yes, this.
Okay. And during those conversations, did you develop a cumulative knowledge of things that I learned this during a conversation, I learned this during a conversation, I learned this during a conversation that you remember?
Mm,
So let's say on day one, he says that he bought a new car. And
okay,
then sometime later, he tells you that he went and bought some new tennis shoes. And then sometime later, he tells you something else that, I've got a new girlfriend or something. Now, would you remember all those events? Did you remember the content of those conversations?
yeah,
Yes?
yes,
But could you pinpoint to a date and a time which conversation you learned that information? Or would you just know that, well, I learned that he bought a new car, but I can't say whether it was in a conversation on June 8 at 8:11 a.m. or a conversation on June 9 at 2:30 p.m.
Right, like, yeah, I don't remember, like, I can remember that, but I don't remember like times and dates and
Yeah.
things of that nature. I
So
don't.
you're like a normal human
Right.
being who will accumulate information, but can't state with precision which day and time telephone call you learned that specific piece of information.
Right,
Okay. So you have a normal human memory.
right,
And you have difficulty remembering from 7 years ago whether you learned a piece of information on a telephone conversation on June 6 or June 7 or June 10. You just know I remember a conversation and I learned this piece of information, but I can't state with precision on a telephone call record which particular phone call I learned this piece of information. Is that correct?
yes,
Okay. Do you vaguely remember having a conversation with a police officer about Michael Reynolds?
yes,
Okay, and are you looking at a transcript of it?
yes,
Okay, and based upon the state's question, are you now aware that the child, Mackenzie, died on June 8 of 2017?
yes,
You're aware of that now?
yes,
Okay. Are you also aware of the fact, and there may be more, well, first of all, how many interviews did you have with the police detective?
one,
One and only one, correct?
mhm,
And is it true that that interview with the detective did not happen until November 4 of 2017? Is that true?
I'm not sure.
Would it refresh your recollection to possibly look on page 1 of that transcript? I haven't seen it yet, but I'm betting on page 1 there may be a date of when the interview happened. The cover page.
The cover page? It don't have,
It doesn't say the date.
no, it doesn't.
Would it refresh your recollection to look at a police report that was created by the police officer who interviewed you? To refresh your recollection about when the police interview happened from the police officer's report.
Yes.
Okay, I'm gonna approach and show you. I'll be darned. Look at that. Okay, so it starts right here,
Mhm,
and then if you flip to the next page, you can see, is that your name,
yes,
your date of birth,
yes,
head notes about what was discussed?
yes,
Okay, looking at this piece of paper, and don't read from it, does that refresh your recollection about the date and time of your interview with the detective?
yes.
And what was that date and time?
November 6th,
November what?
November 4th,
At what
2000,
time?
12:07 p.m.
Okay. So you don't talk with the detective until November, and he's asking you about events that happened in June.
Right,
Is that correct?
right,
So as you are answering this question, are you providing him with an amalgam, a totality of all the information you have that you have learned from June 8 to November 4, or are you just saying only the information you learned on June 8 at 8 in the morning?
all of it,
All of it.
right,
So all this information that you're providing to the police detective is not just the information that you learned during a telephone conversation at 8 in the morning on June 8, but you're telling them all the information you've learned from June 8 all the way to November 4.
right,
So it's entirely possible that when you tell the detective,
It's on the last page.
oh, it's on the last page?
Yes.
I haven't seen that one before, so I apologize. I have seen it before, but not this morning. Sure enough, she is correct. It is on the last page, not the cover page. Okay, so when you're telling the detective that Michael stated that a little girl had passed away, is that something that you could have learned in July,
Yes,
August,
yes,
September,
yes,
October,
yes,
or the beginning of November before the interview.
yes,
But you are not saying that you learned that during a telephone conversation at a specific time on a specific day,
right,
because your memory can't do that. Can your memory do that?
no,
Well, good, because mine can't either. Okay, so this information you're providing is just basically your cumulative knowledge about whatever you have learned during that 5-month time period.
right.
Okay. Okay. So it's clear that you were having a number of conversations with Mike.
Yes,
Yes. Did he ever admit to you during any of those conversations that he murdered a baby?
no,
Thank you. Nothing further.
Any redirect?
Just briefly, Your Honor. So, Mr. Jordan, just to be clear, you do recall conversations that you had with Mr. Reynolds in June of 2017, specifically June 8th of 2017, during your review of the transcript of your conversation with the detective. Is that correct?
yes,
Okay. And it was your recollection in November of 2017 that the defendant told you that he went to work that day.
yes,
Okay. And at some point during those conversations, you also learned that a little girl had passed away.
yes.
Okay, thank you. Nothing further.
Nope. Questions from the jurors? All right, Mr. Jordan, thank you for being here.
All right, thank you.
Next witness.
Just give us 1 second.
Sure.
Trying to figure out which one of our professionals have arrived.
State calls Monae Patrick. Your Honor, if we may, I apologize. That is actually going to call Jason French.
Okay, Jason French it is.
Just face me and raise your right hand. You swear affirm testimony you'll give the truth, the whole truth, and nothing but the truth of God. Please raise your hand, have a seat. Good, check one. Can you state and spell your name for the record?
Jason French, JASONFRENCH.
Good morning, Mr. French.
Good morning.
Mr. French, how are you currently employed?
City of Atlanta, Department of Watershed.
So you have a busy job.
Yes,
And do you know someone by the name of Calvin Duffy?
I do.
What is your relationship to Calvin Duffy?
Kevin is, he's kind of like family, but he works for me doing, little side work, cutting grass and stuff like that. He started working for my uncle who's deceased now,
What's your uncle's name?
Arthur Searcy,
Can you spell that last name for me?
Searcy.
Thank you. And how long has Calvin worked for your family, whether it was for you or your uncle?
Maybe 20 years or better, I'm not sure.
And what type of hours does Calvin work?
Usually, morning to afternoon. Back before I was before my uncle passed, he would go, work for my uncle during the mornings, and then I would drop him off in the afternoons. But yeah, usually for morning, or he'll show up mid morning to afternoon, probably about 4 or 5 o'clock. I drop him off.
And how does Calvin normally get to work?
Either he's picked up or he just show up.
And when you say you pick him up, where do you normally pick him up from?
His sister's house or Dee's house or wherever he is.
And where do you typically drop him off at?
Wherever, maybe at his sister's house or at a gas station, wherever he wants to be dropped off at.
Okay. And do you recall in June of 2017, Calvin was working for your uncle?
I think he worked for him that day. I remember dropping him off here.
You said you remember that day. What day are you referring to?
The day, the 17th, I remember dropping him off that afternoon, but I think I was at work the morning or whatever.
Did something happen that day that's making that day stand out in your mind?
No, I was just told that, about the murder of the child, but no, I mean, nothing just sticking out.
But that day specifically, did you talk to a detective about that day as well?
Yes, previously, yes.
So the day March that we're talking about, was that June 8th of 2017?
Yes.
And did Calvin work that day?
Yes, he did, because when I got out of work that day, he was at my uncle's house.
And did you drop him off?
Yes.
Where did you drop him off at?
I think it was at the the BP on Bikehead.
Is that one of Calvin's normal spots?
Yes.
And was that a normal work day for Calvin, what you recall?
Yeah, usually.
And with Calvin, you said he would normally show up in the morning. What time are we talking about?
I don't really know. Maybe, I guess, anywhere between 7, 8, but it's between 7 and 9. I'm not sure.
Okay.
I mean, I've been told he's showing up earlier. I can't really give you a specific time.
Okay. All right. Is Calvin shown up for 20 years? Calvin has shown up at for work for your uncle and for you for 20 years?
Yeah, I'm just saying roughly. I don't know exactly, but it's been a long time.
Okay. He's still employed by you?
Yes.
All right. That's the witness. Thank you.
No questions.
Okay. Jurors, questions? No? All right. Mr. French, thank you for your time.
Thank you.
Appreciate it. Sure. We're going to take our morning break a little bit earlier, but that's only because we are flying through witnesses. And I think the state needs to regroup and figure out who's next for this morning. So, ladies and gentlemen, take your notepads with you. Don't talk about the case, no outside research, and we'll get you back in here close to 10:30. I need juror 10, Mr. Wood, to stay put. The rest of you to the jury room
All right.
or the hallway. All right, the rest of you can be seated. Juror 10, are you the one who indicated you might know a witness?
Yes.
Great, I guessed right. So I think we're talking about Ms. Bryant, who I'm gonna ask to step outside. Thank you. Is that the correct witness?
Yes.
Okay. Why don't you tell me and the lawyers why you think and how you think you know Ms. Bryant?
I think she's my wife's cousin,
All right.
I know she manages several McDonald's. I've only seen her once, but I don't, I don't know her name. I didn't even know her name.
Got it. That's how distant the connection is that you're thinking, wait, my wife has a cousin who may manage some McDonald's and maybe she looks kind of familiar. That's it?
That's it.
We see each other every weekend and have fellowship.
I've seen her one time. I think I've seen her one time, and that one time may have been 7, 8 years ago.
Okay. Anything about that extremely limited connection that you might have with Ms. Bryant cause you to treat her testimony differently from anyone else's testimony?
No.
Okay.
That's why when I immediately saw it sent out red, sent out red flags. So I said I better be real transparent.
Good. No, and writing this down was very transparent. I appreciate you doing that. But the red flags you're referring to aren't, I know I shouldn't believe her because that's my sister's lying cousin, or I should believe her because that's my sister's best cousin who has saved the world.
No, it was just that in the beginning, and I don't know the correct name of it. They gave a list of people witnesses that we may know.
Right.
I didn't know her,
Right.
because I don't know her name.
Got it. You did the right thing by disclosing. Ms. McCauley, any questions that you want to propound to Juror 10?
No, Judge, thank you.
Mr. Shepherd?
No, Your Honor.
All right. Thank you, sir. Join the group. Appreciate your candor. All right, Ms. McCauley, I see no issue with keeping Juror 10 on the jury. Any issues from the state?
No, Your Honor.
Mr. Shepherd, anything from the defense?
No, Your Honor.
Okay. Ms. McCauley, anything before we break for the break?
No.
You'll have witnesses when we're done with the break?
Yes.
Yep. Not a persuasive sounding yes, but we'll see what happens. Mr. Shepherd, anything from the defense?
No, and I have had witness issues also. So I'm very compassionate towards the state because we are going to witnesses a lot faster than I thought we were going to.
Understood. I'm glad that we inoculated the jurors yesterday that we might end early. Early might mean 11 a.m. But hopefully we get through lunch.
I asked Sluss to be here at 1. I think that's the earliest he said he could get here.
Okay.
And we got 3 here.
Good.
No candles. One's being a problem, and I need to sit up.
Good. Well, that's what breaks are for. All right. Thank you, everyone. See you in about 10 minutes.
Thank you. See you about that. Yeah. That's what she was from the jury. That's what she was prosecuting. So she was trying to trick every jury to say something that's not true. And that's the English to put their first one in. So I said the bathroom. Yeah, so basically the point that you made earlier. So that's what she's gonna do. And even if you're answering questions, truth, she's gonna make you look like a lawyer, liar, just like you tried to do the truth. And then I got to fix it. You see me fix it. Yeah. That this information, you can't say what you learned about Junior for the twice that you learned about. And nobody could have made you pay for it. You see what I'm saying? That's how tricky she is. With no laws, no ethics, no code of conduct. She may have noticed from her opening statement. She said, I want you to return both the guilty as fled. She didn't ask for just fair or proper verdict. She asked for a guilty verdict. And that's her objective. And there were very few causes that she observed. She gets to that point and trying to trick a witness into saying something that's not true. And nobody answers the question truthfully to make it look like a lie. It's within her arsenal what she uses appropriately. She's going to do it to you. Once again, I think that another thing that I've learned about that, getting through life instead of lying about. So I'm doing everything I can not to piss him off. Because if I get him mad at me, he's going to take me out. And I'm doing everything I can not to piss them off. So maybe one or two of them will stand up and say, I'm not convicted. And we'll get into a trial at some point in the future. So our objective is a mistrial, or if we do lose, they can get life instead of life without. If you testify, I think it's going to guarantee the guilty one. And life without. If you don't testify,
It's just gonna take everything that's done, everything that you trying to do. It's gonna, they're gonna disregard that, and basically her verdict is gonna be told on me and my credibility.
and she's going to question you about things that have nothing to do with the case. Yeah. The things that happen after the case. Where you went, what you were doing, why'd you go get your jacket? I personally think you probably had to go get your jacket. That's why you went to get your jacket. You went to your leave first. What was in the jacket?
We can talk about it, I tell you now, but I don't know if,
You see what I'm saying, but it's something in that jacket.
yeah, so it's like.
Okay. I know, I'm smart, I'm not a idiot yet.
Right, I appreciate that.
And you know, I'll do the best I can, just remember that, even if we lose or if we lose. All right. Ah, help me, Lord.
I'm gonna go this way.
Well, it looks like we might get to go home early today. Good. You're stuck, right? No. But at least if we're out of here, then your job becomes easier, right? And the rest of the day you can coast.
Sure.
So that's right.
They fast track, I mean, he didn't go to car, he didn't go that car. Really? It was straight surprise for you.
What was that, Kyle?
Yeah, man, they got an album now, they made it drop.
Gotta pay them lawyers.
Well, I'm exhausted. You know, Halloween is a lot of work.
Yeah.
You know? Because you have to interact with so many people. Yeah, and then obviously it put me really far behind on the things I normally do in the evening when I'm in trial, so I didn't get to bed until after 10, which for me is catastrophic. So I'm exhausted today.
And I wish.
I will definitely not object if the state runs out of witnesses around 3 o'clock.
I wish I could go to bed at 10.
So what?
I said, I wish I could get to sleep at 10.
I know.
You know, I'll be up doing transcripts.
Yeah, and it's a trial thing that trials are so exhausting that if I don't get a good night of sleep, I start running out of energy around 2 or 3. And, you know, yes, I have an overwhelming amount of work to do. But court reporters right now, there's a shortage.
Big time.
And you have incredible job security. Because just people aren't going into that line of work anymore. I think it's a generational thing.
Yeah, my generation is tiring out.
And that the new generation use it as work.
It is work.
Yeah, I mean, and they're like, I don't do that. Sit there all day, typing away, they have to, you know, it's too much work for Gen Z to contemplate. Plus, there's the delayed gratification of it. You have to do all this stuff and you're making no money. Like law school. You're doing all this stuff and you're making no money. They want a paycheck while they're being trained to be a court reporter. Mm-hmm. And then you got the darn lawyers yelling at you, where's my transcript, where's my transcript?
I'm gonna listen to y'all.
I already looking for a transcript.
No.
You know, and I try. The only time that I'm like, I need that transcript, and it's a pretrial motion, and there's stuff in it that I need to attack the police officer in the trial to get changed. But if it's a appeal and I'm doing a trial transcript, I'm like, you know, take your time, because the minute you finish that transcript, I gotta start writing my brief. You know, or I gotta start doing, I have to, you know, so my work doesn't start, so I'm always like, take your time. In fact, I just pulled 2 of the backlog, court reporters, I can't remember their names now, where we did a big motion for a new trial hearing for Judge Hansen. And so, I emailed them, hey, when the transcript's ready, send it to this email address. And they were like, well, it's going to take me a minute to get to it. I said, take your time. I am no hurry whatsoever, because my brief is due 90 days after I get the transcript. So, yeah, take till 2028. Because my clock starts running the day you send that email.
Yeah, but we have time to constrain.
I know, it's not for me. You know, I remember some of the judges on these appeals issuing orders that the transcript shall be filed by this day, and I'm like, you know, why are you putting in an order like that? You know, but I'm not a judge. But yes, you definitely have a very difficult job. Many young people are not willing to take on that level of work and stress and time, and that's why we are huge. Okay.
Thank you, Mr. Rivers.
Okay. So as far as I can figure, we have 9 witnesses for today. We have a legal start and 2 more, we have 4. As far as I can tell, the only one who's gonna take any weight is gonna be Ronald Sluss. He's gonna be the powerful, where they're tracking your movements. So this is kind of the new one we got last night, and basically, he's just gonna talk about stuff, and it's really neat how they can track people now. This is super cool about how they can follow you as you're moving around. So they get these vectors and your phones hitting off these towers. This is super cool stuff. So these towers, and they have 3 sides. And there's some of these are 6 sides too, if you rarely see them. So they can triangulate which side of the tower they're on. And then based upon how long it takes the signal to go and come back, they can get that, how far away from the tower you are. So they can put you inside the code, but because of the length of time, you can kind of get an idea of where you are within the code. Okay? So using GPS triangulation, they can get you pretty close to the window. Okay? Now, obviously, you totally have a bunch of stuff that was true. There's nothing we can do about that now. But I have another thing I want to tell the jury about. Correct about the one thing. I have another theory I want to tell you about a little bit after you hear the other things. So you don't make any calls until 8:48 now. And that's what they're saying. They can also track you other ways now. This comes up. It's much more sophisticated now. See what I'm saying? That's very good. Yeah, so you know, we're saying, here you are, you're at a package store. And then you're saying you're moving, and it's kind of flattening as you're moving around that way, wherever you go. Okay. So here you are, you're traveling. It's really cool. This is it. Now the new world, the way they do the new one, the current, like if you do something now, they take your cell phone, you can actually have, it can show you moving. It's really cool. And so now you're making 31 calls. You're on your phone block. Finding like making all these calls. She never put that thing down. I swear to God, one night I saw her, she was asleep. So now you're here, now you go back at 10:46. That's where you go back to the jacket. And move. So now you're in Amazon.
Oh, that's on the grade. Oh, here you are, see you in way. So you end up at the children's hospital. It's pretty cool stuff. I mean, obviously, at least you guys do that. But the new ones are so cool because it's a moving map and it just follows you. But how do you so that is the one guy who's gonna talk for a while, because it's gonna take them a while to do all of this stuff, but he's gonna talk to people. And it is what it is. Anyway, so that's, we got this. I bet you might want to see this beforehand. We're gonna be up there in a few later this afternoon. But that kind of gives you an example of resources to state and what we have stuff. They're that same thing, unlimited resources. But anyway, so that'll be this. Let's see what argument that.
All right, Ms. Rivers, are you ready?
Yeah.
Okay, Ms. McCauley, ready to have the jurors come back in?
Yes, Judge.
Did you solve your witness issue?
Yes, I did.
Great. Is anyone bruised?
No.
Okay, Mr. Shepherd, ready for the jurors to come back in?
Yes, Your Honor.
Let's bring them in, please.
For jurors.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back from break. See if the state is ready with its next witness.
State calls Natalie Bruner.
You swear affirm that the testimony you will give, the truth, the whole truth, and nothing but the truth, self God.
I do.
And I see. Can you state and spell your name for the record?
Yes, my name is Natalie Bruner, Natalie, Brunner.
Good afternoon, Ms. Bruner. How are you currently employed?
I'm a senior investigator with the Fulton County District Attorney's Office.
And what are some of your duties and responsibilities as a senior investigator with the Fulton County District Attorney's Office?
Right now, I primarily prepare unindicted cases, which would include collecting any additional evidence that we would need to prosecute the case, speaking with victims and witnesses, and just obtaining any relevant information that might be missing or needed to prepare a case for court.
And prior to serving in that capacity, where were you assigned?
Previously, I was assigned to the Crimes Against Children unit.
And crimes against children, what were some of your duties and responsibilities there?
They were similar, assisting preparing cases for prosecution, gathering additional evidence that may be necessary for a case, conducting interviews with victims, witnesses, professionals, and collecting potentially jail calls in a case, just any other evidence that we might need to take a case to trial.
And did you have the occasion during that point in your assignment to work on Stevens versus Michael Reynolds?
I did.
And what did you What types of things did you do on that case?
I was requested to get a search warrant for some Uber records. And I was also trying to get some evidence to either confirm or deny a statement that had been made by the defendant in the case.
And the statement that you were trying to confirm or deny, what was that in regards to?
The defendant had at one point made a.
Your Honor, I'm gonna object on the double hearsay nature of this, unless she's the one who actually heard the statement being made. She is therefore going to be saying, somebody told me the defendant said, which is gonna be double hearsay. I understand how they get through the first hurdle, but not the second hurdle.
Okay, I guess it would depend on who the somebody is, and then we'll work through that.
Well, there was no foundation laid before she was about to say what was said, so I thought I would proactively
Okay,
stop the statement from coming in.
got it. I may have missed the in-between step. I thought we hadn't gotten yet to whom did she speak?
Well, she asked, what was the statement, which means the hearsay is about to come in with this question.
So
Okay.
Judge, just to kind of fix the preemptive objection to a question that hasn't been asked, I'll just go ahead and ask some more questions.
Okay,
All right.
great.
Investigator Bruner, did you have an opportunity to review the case file that was provided by the Atlanta Police Department?
I did,
Did that case file include recorded statements?
yes,
Did that case file also include written statements?
yes,
Did that case file include recorded statements of the defendant?
yes,
Did you listen to those statements?
yes.
All right.
Which is all I object.
Okay. You can renew it when we have more context. Keep going, Ms. McCauley.
Thank you. Investigator Bruner, what was the statement that you were seeking to either support or discredit that was made by the defendant?
He had indicated at a point during the investigation that he had been at a medical appointment with his child on the morning of this incident.
Upon hearing that statement, what steps did you take?
He, based on the information we had, which was simply a possible location of the doctor's office, I checked in that area for any medical providers that would provide pediatric care, which included Children's Hospital and a private office called Old Fourth Ward Pediatrics in that area.
And what was the area that you were exploring?
The defendant had indicated it was an office that was off of Boulevard, close to the highway.
And either through your role as an investigator with the Crimes Against Children Unit or your experience as an investigator generally, were you familiar with what pediatric offices were in that area?
Generally, yes.
And did you obtain any records from either entity, the Old Fourth Ward Pediatrics or Children's Healthcare of Atlanta?
I just received a letter from Old Fourth Ward Pediatrics.
Okay. What about, we'll start with that. I'm going to show you what's been marked as State's Exhibit 18. Take a look at that.
Okay.
What is State's Exhibit 18?
This is a letter that I received from Old Fourth Ward Pediatrics regarding my inquiry as to whether the defendant's child had been a patient there.
Is that a true and accurate depiction of the correspondence that you received from Old Fourth Ward Pediatrics indicating an absence of their records?
Correct.
At this time, the state would move to admit State's Exhibit 18 into evidence.
No objection.
States 18 is admitted.
No. So, investigator, June 7, 2022, Old Fourth Ward said there's no patient who has ever come to our practice with this name and date of birth.
That is correct.
And is that the name and date of birth of the defendant's child?
That was the information I received, yes.
Now, you said you also checked with Children's Healthcare of Atlanta. And did you receive a response from Children's Healthcare of Atlanta?
I did.
I'm going to show you what's been marked as State's Exhibit 19. And for the record, I've shown it to Defense Counsel. a look at that, let me know when you're finished.
Okay,
Have you had a chance to look at State's Exhibit 19?
I have.
What do you recognize State's Exhibit 19 to be?
This is the order that I sent to Children's Hospital and the response I received from them.
And does that response reflect an absence of the records, of records existing for a child treated by the name of Michael Reynolds?
It does, yes.
At this time, Your Honor, State would offer State's Exhibit 19 into evidence.
No objection.
Admitted.
And what was the response from Children's Healthcare of Atlanta?
That there were no records of this patient being treated on or around the date of this incident.
Now, Investigator Bruner, you had mentioned earlier that you had also been asked to obtain some records from Uber.
Yes.
Were there records that already existed in the case file that was received from the Atlanta Police Department about the absence or existence of records from Uber?
I don't recall what was there was a mention of the defendant having been driving for Uber the day of this incident, but I don't recall if the initial investigation tried to obtain any records or not.
Right. Did you subsequently obtain records?
I did.
All right. I'll show you what's marked as State's Exhibit 22, the 4-page one. Look at that. I'm finished.
Okay.
And are those the records that you received from Uber?
They are.
Do they appear to be an accurate copy of what you received from Uber?
Yes, they do.
At this time, Your Honor, and are they accompanied with a certificate of authenticity?
Yes.
At this time, Your Honor, the state will tender State's Exhibit 22 into evidence.
No objection.
22 is admitted.
And Investigator Bruner, when Uber responded to your request, what information did you seek?
I provided the defendant's name, date of birth, and I believe driver's license information to Uber in my request. I asked them for any record of him being a driver for Uber. And also if he was in service the day of this incident for any GPS data related to his account.
And is this the response that they sent?
It is.
That so for May 11th through present, the vehicle that he was driving, and then they were able to attach some GPS data?
That is correct.
Okay. And just to, Investigator Bruner, this just looks like random GPS data from what you received?
That is correct.
Okay. Were you asked to interpret or plot this data in any way, shape, or form?
I was not.
Okay. Are you familiar with the timestamps these records are provided in?
According to the page, it is in UTC.
And just from your knowledge as an investigator, what is UTC?
UTC is a time code. It's typically used by like cell phone providers, other companies that receive GPS or that use GPS data. It's kind of a, I guess, an industry standard. It is different from Eastern Standard Time, by, I believe, 5 or 6 hours, but I can't remember which direction.
Is it about 4 hours, give or take, daylight savings time? Would that be accurate?
That sounds about right.
But again, you didn't do anything with this data beyond just receiving it.
That is correct.
All right, thank you. I'll pass the witness.
Mr. Shepherd, any questions for the investigator?
So the statements that you were asked to check out were on some form of digital device.
I don't recall. I received information that the defendant had indicated that he was with his child at a medical appointment. I investigated that claim, but I don't.
Did you actually watch the statements yourself? Or did somebody else tell you what was in the statement?
Honestly, I don't remember. It has been several years since I had any involvement with this case.
Okay. Do you know what day the statements were made?
I do not.
So the statements could have been made months after June 8th.
That is possible, yes.
Okay, and at what point in time the memory of what you were doing on June 8th may have been unclear or cloudy?
What I was doing on June?
No, what? So at some point, the defendant makes some statements about what he was doing on June 8th that you were going to investigate.
That is correct.
But you don't know when the defendant tried to recall in his memory what he was doing on June 8th.
I do not recall, no,
And
when that.
What was the date on your inquiries?
The date on my inquiry and the date I received, well, the date I received the letter from Old Fourth Ward Pediatrics is July 7th, 2022, which would have been pretty close in time. I can't remember if they actually gave it to me that day that I went by their office or within a few days.
Okay, so July
of 2022.
2022. And what was the other inquiry that's in front of you?
This, I ordered the, I made the request to Children's Hospital on July 1st of 2022.
Okay.
And they sent their response on August 17th of 2022.
Okay, so sometime between June 8th of 2017 and July of 2022, what is that, about 5 years?
It is.
Mr. Reynolds made some statements about where he was on June 8th of 2017, and that's what you're investigating.
Yes.
And those statements could have been made about where he was 4 years ago. And you're investigating whether he accurately remembered what was going on that day.
Yes.
All right, thank you. Nothing further.
Ms. McCauley, anything else? Okay, jurors, any questions for the investigator? Yep. Thank you. Investigator Bruner, do you know to whom Mr. Reynolds said he was taking his child to a doctor on the day in question?
I do not.
Do you know that it was a statement to law enforcement, or do you know that much? You just don't know who in law enforcement, or you just know this statement was made?
I know the statement was made. I do not have any indication of who the statement was made to.
Okay, thank you. Ms. McCauley, any follow-up based on that?
No, Your Honor.
Mr. Shepherd?
No, Your Honor.
All right, thank you, ma'am. Next. Witness. Gonna try again? Okay.
When you sit, can you face me and raise your right hand? Before you sit. Do you swear or affirm that the testimony you will give is the truth, the whole truth, and that's what you self God? Yes. Put it on your hand, see. Can you say spell your name for the record?
Monae Patrick, Monet, Patrick, Patrick.
Good afternoon, Ms. Patrick. Can you tell the jury how you are currently employed?
Currently, I'm employed as a victim specialist with the FBI Houston Division.
And at any point were you employed with the Georgia Center for Children's Advocacy?
Yes.
How long were you employed with the Georgia Center for Children's Advocacy?
From 2016 to 2023.
And what was your title when you worked for the Georgia Center for Children's Advocacy?
My last title when I worked there was I was the lead forensic interviewer and the MDT coordinator, the multidisciplinary team coordinator.
And at that particular time before you left, what were your roles and responsibilities?
So basically my job was to conduct forensic interviews when we received referrals from either law enforcement or DFACS. And also I helped facilitate the multidisciplinary team meetings in DeKalb County.
And prior to that, did you have any relevant experience working with children?
With my employment through the Georgia Center, yes. Also worked at local domestic violence shelters that had children at them.
And Ms. Patrick, how do children normally get to the Georgia Center for Children's Advocacy?
So usually we're getting a referral from local law enforcement.
Okay. And I'll refer to it as the GCCA, does the GCCA work with law enforcement?
They're usually one of our partners that we'll work with, yes.
Okay. And what is your educational background?
I have a bachelor's in sociology and a master's in social work.
And do you have any specialized training in interviewing children?
Yes.
Can you please explain to the jury?
Yes, so I've attended the main child first training, which is about 40 hours, as well as advanced child first, which goes into a lot more detail about talking with children and those dynamics.
And overall, how many hours of training would you say that you've done?
In relation to just forensic interviewing?
Yes.
At least probably like 70, 80 hours.
And how many forensic interviews have you personally conducted?
A little over 1,000.
Okay. And have you observed other forensic interviews?
Yes.
How many, if you were to give a rough estimate, how many other forensic interviews would you say that you've observed?
At least 50.
Okay. And did you participate in peer review?
Yes.
And can you explain or describe to the jury what peer review is in terms of forensic interviewing?
So peer review is essentially where other forensic interviewers throughout the state will meet in order to go over and review each other's forensic interviews, usually to give critiques, feedback, get updates on best practices, things like that.
And how often would you participate in peer review?
Usually at least once a month with with other external forensic interviewers at other centers, and usually at least once a month internally with other forensic interviewers at the center.
And Ms. Patrick, did any of the training that you received have courses that dealt with the topics of coaching and also suggestibility?
Yes.
Did any of those courses involve the techniques of forensic interviewing?
Yes.
Your Honor, at this time, the state would move to tender Ms. Monae Patrick as an expert witness in the field of child abuse and forensically interviewing children who are victims of child abuse, also the techniques of forensic interviewing, and disclosures of abuse and issues of memory and recall.
That was a lot.
Yes, Your Honor.
Mr. Shepard, I know you've had notice of this and had a chance to think about it. Do you have any objection to having Ms. Patrick qualified in those fields?
No, Your Honor.
Do you wish to examine her on her qualifications at this point?
Not as to her qualifications, but I may have some cross-examination after the state finishes.
Definitely check on you then. Okay, Ms. Patrick, you are qualified for the purposes of this trial in those related fields that Mr. Jordan just described for us.
Okay.
Ms. Patrick, can you explain to the jury what is a forensic interview?
So basically, a child forensic interview is essentially a conversation with a child where we're basically going in there neutral, and it's the main purpose being information gathering from that child and having them recount their experience with either one event or multiple events.
And typically, why would a child be referred to the GCCA?
Usually they're referred there so the child doesn't have to give their statement to a police officer or detective. They're talking with someone specifically trained to talk with children.
Now, is there a typical procedure or protocol that's followed at the GCCA?
Yes.
And what is that protocol?
So the protocol underneath Child First usually follows about 4 basic steps, usually with some flexibility depending on the child. But usually that starts off with introduction and rapport. That second phase being the transition to the topic of concern, the third being exploring details, and the fourth being closure.
Now, Ms. Patrick, how does a forensic interview differ from that of a therapeutic or clinical interview?
So although the interview is trauma-informed, at the end of the day, it's not therapy. The main goal still at the end of the day is just to get from that child in an appropriate way their account of what may have happened to them or something that they witnessed.
And where are children normally forensically interviewed at the GCCA?
So we usually have separate forensic interview rooms that are wired for video and sound.
Okay. And when these forensic interviews are conducted, who is normally taking place in the interview?
Can you repeat that question?
My apologies, I worded that poorly. You stated that the interviews occur in a room, is that correct?
Yes.
Who is normally in the room when those interviews are conducted?
In the actual forensic interview room, it's just the interviewer and the child.
Okay. And why is that?
Just to limit any influences on the child and the statement that they might make.
And prior to interviews, Ms. Patrick, do you normally meet with the caregivers of the child?
Usually briefly, just in case they have any immediate questions for us prior to the interview. Usually a separate family advocate will meet with the parent or the caregiver while the interview is happening.
And why does that occur?
Just so those roles can be separated.
Generally, Ms. Patrick, what information do you have prior to a forensic interview being conducted?
Usually brief information provided by the detective who sent in the referral. And usually there's a conversation that takes place prior to that interview.
Previously, Ms. Patrick, you stated that there's a child first protocol and it has an amount of steps. Can you explain to the jury what those steps are?
Yes, so the first stage, the introduction rapport stage, is essentially just orienting them to the room. We usually give them instructions. We let them know that if they don't know something or don't remember something, that they can let us know, that they can correct us if we get something wrong that they told us. And if we ask them something that usually doesn't make sense, that it's okay for them to tell us that they don't understand. We usually often tell them about the cameras in there, that there's someone else observing from a separate room. And then we'll usually just kind of ask about family, about their day, usually not about what they're there for during that stage. Usually during the transition to the topic of concern, it's kind of what it sounds like, we're transitioning to why they're there. That can look different for the child. Sometimes we'll just ask them, like, do you know how come you're there today? If they don't, there's other questions we can kind of ask to kind of get to the point. The third, exploring details, that's essentially just us getting as much clarifying information that that child can give based on their age, developmental ability, and just as much as they can give without putting too much stress on them. And then closure is just asking them if they have questions for us, usually talking about something that's not related to why they're there. And sometimes we'll usually ask safety questions.
And Ms. Patrick, do you use open-ended questions during forensic interviews?
Generally, yes, we like to start with open-ended questions.
And why is that?
Usually when you ask a child more open-ended questions, you tend to get more of a narrative from the child as opposed to limiting them with too many direct questions.
Now, why don't you ask direct questions in a forensic interview?
So we will sometimes ask direct questions, but with the end goal being to open it back up to more open so that they can give us that narrative. But we tend to not like to ask too many direct questions because at the end of the day, we want the statement to be from that child themselves.
Why is it, let me ask it this way. When leading questions are asked, can that affect a forensic interview?
Yes.
How can it affect a forensic interview?
If you're asking a child to leading questions or suggestive questions, you can sometimes be kind of. Am I still? Oh, it's okay.
Something happened with the audio. Hold on. Let's keep going. I think we fixed it.
Okay. And I'm sorry, were you in the middle of?
So generally we won't ask leading or suggestive questions because at the end of the day, we don't really want to put words in the child's mouth or lead their statements in any way. We want to limit that if at all possible.
Ms. Patrick, does an interview vary based upon the age of the child that you're forensically interviewing?
Yes.
How does it?
So generally smaller children might be able to give us maybe a who did what, maybe a where, but it might be a bit more complicated for them to give things that are more abstract in nature. Sometimes time can be a little tougher for smaller children to understand.
And does a child's developmental level also affect how an interview is conducted?
It can.
And can you explain how that can affect a forensic interview?
Yeah, depending on what's kind of going on with the child, it may just affect the way that they're able to communicate, potentially the way that they understand the question. Sometimes if someone's at a lower developmental level, like I mentioned, they might have issues with abstract questions. They might need things that are more concrete.
Now, Ms. Patrick, can you describe what the term suggestibility means in terms of forensically interviewing a child?
So suggestibility is the idea that something someone else said or maybe prompted somehow altered that child's statement. But everybody is suggestible to a certain degree.
Okay. And does the age of a child affect how suggestible the child might be?
Yes.
Can you give an example of that?
So again, usually smaller children, usually children like under 10 tend to be more suggestible, but usually after that age, usually children aren't any more suggestible than an adult.
Now, can you explain to the jury, Ms. Patrick, what the term coaching means in terms of a forensic interview?
So coaching is the idea that someone explicitly told someone what to say or told them what not to say.
And can age affect the level to which a child can be coached?
It can, yes.
Now, what does the term disclosure mean in terms of forensically interviewing a child?
So a disclosure is essentially an outcry that the child has said that something happened, that they witnessed something.
Okay. And are there different kinds of disclosures?
Yes.
What are those?
So sometimes we'll have what's called immediate disclosures. Like it sounds like the child said immediately what happened. Delayed disclosures is usually can be anywhere from weeks, months, years down the line when that child or maybe even adult finally felt comfortable talking about what happened.
Now, can the age of a child impact their disclosure?
It can, yes.
How can it?
Depending on, again, if some of those factors were around like coaching, if they're more susceptible to it, it might affect if they were ready to talk about it. Sometimes just other influences can affect if that child's ready to disclose. Family dynamics, if there's some sort of fear, shame related to what's going on with them.
Okay. Now, can you explain to the jury what the term contextual detail means in terms of forensically interviewing a child?
So contextual details are usually things like where was someone at, what were they doing, things they could see with their own eyes, smell, hear, taste, depending on the context.
Now, earlier we talked about coaching and suggestibility. As a trained forensic interviewer, do you look for signs of coaching and suggestibility?
Yes.
Can you give examples of those?
So usually we'll do source monitoring. So that's usually sometimes asking the child, well, where did you learn this information? Is this something you experienced firsthand? Or is this something someone told you? Sometimes we'll just explicitly ask, did anyone tell you what to say before you came here today, or what not to say?
Now, Ms. Patrick, what is the difference between a forensic interview and live testimony in a courtroom for a child?
So usually a forensic interview is in a very controlled environment. We're there to talk about what happened to them that day. And everything's basically on their own terms. We let the child know that if they need a moment, they can take it, as opposed to, say, they're in a courtroom. This is a lot more overwhelming than it would be in a one-on-one situation.
Now, are there any factors that might account for inconsistencies in a child's statement between a forensic interview and their testimony in a courtroom?
Sometimes trauma can affect the way that a child gets what happened to them. Sometimes just time in general can affect that child's testimony. And also maybe just sometimes depending on how many times they've been questioned.
Now, can the distance in time between the incident and live testimony, can that affect a child's testimony in court?
It can.
Now, Ms. Patrick, did you have the occasion to interview a Quindarius Duffy on June 15th of 2017?
Yes.
And do you recall where that forensic interview was conducted?
It was at our office in Fulton.
Okay. And prior to today's proceedings, did you have the opportunity to review that forensic interview?
Yes.
Your Honor, I have showed defense counsel what has been previously labeled as State's Exhibit 12. Ms. Patrick, I'm placing in front of you a disc. Do you recognize what has been labeled as State's Exhibit 12?
Yes.
What is State's Exhibit 12?
It's a copy of the forensic interview.
Okay. And when you reviewed that prior to today's proceedings, did it appear to be a true and accurate depiction of the forensic interview that you conducted with Quindarius Duffy?
Yes.
Your Honor, at this time, the state will move to tender into evidence State's Exhibit 12.
No objection.
12 is admitted.
Your Honor, I'll ask a question while Ms. McCauley is pulling that up. Showing defense counsel what has been labeled as State's Exhibit 11.
We can approach on this.
On 11?
Yeah.
Okay. Can I see?
Yeah. The interview speaks for itself. The interview is evidence. I think the interview summary is inappropriate to this set because it's basically her take on what happened.
Okay.
And it would be continuous with this interview.
Mr. Jordan, do you think that this ought to go back to the jury, or you would just want to make sure it gets into the record? Two different things.
I would just want to make sure that it's the record if I agree with counsel.
Sure. All right. I don't disagree with you, Mr. Shepherd, but if it's just being made part of the record, that's different than would it go back to the jury. Yeah.
Yes, Your Honor, this is published not to go back.
Okay. So as I understand it, Mr. Shepherd, 11, I don't know, I'm not remembering if the foundation has been laid, but assuming the foundation is laid, I think you saw it and raised your concerns, but assuming a foundation is laid, a proper foundation, I think it can be admitted into the record. I don't think it would go out to the jury for continuing witness reasons. But the intermediate question is, could it be published during the course of Mr. Jordan's interaction with Ms. Patrick? And I don't know if you have an objection to that.
No, I don't. I just wanted to be clear that I thought it was not appropriate under continuing witness rule to go with the jury.
Got it. Okay. You may need to ask some more questions before you tender it, but I think we know where this will end up.
Ms. Patrick, did you complete a forensic interview summary as a result of your forensic interview with Quindarius Duffy?
Yes,
Is that something that you would normally do following a forensic interview with a child?
yes.
I'm approaching the witness, whether it has been previously labeled as State's Exhibit 11. What do you recognize State's Exhibit 11 to be, Ms. Patrick?
The synopsis that I wrote for his forensic interview.
Is it a true and accurate depiction of the forensic interview synopsis that you yourself produced?
Yes.
Your Honor, at this time, the state will move to tender into evidence State's Exhibit 11.
No objection for purposes of introducing the record, however, based upon the nature of the summary that I would object to it going out with the jury under the continuing witness rule.
Okay. So it's admitted, it's made part of the record. You may publish it. My tentative ruling is that it would not go out with the jury. We'll have another more comprehensive discussion about that when both sides have rested and we're figuring out what part of the corpus of evidence, physical evidence, goes back with the jury. But currently this would be in the pile of does not.
Yes,
Okay.
Your Honor. At this time, Your Honor, the state will publish and place State's Exhibit 12.
Okay.
So not 11, you're pivoting to 12 now. Okay.
What's the exhibit number?
The 11 was the summary.
11 is the document, 12 is the recording. And now Mr. Jordan is seeking to publish State's 12. Any objection to that? Okay. Just for everyone's planning purposes, ballpark, how long is this?
52 minutes.
52 minutes. Okay. If you all can't make it all the way through 52, start waving your hands. We'll make sure audio and video work. But otherwise, that'll be when we're going to have to stop at noon if certain lawyers show up for something that I have to hear here, but then we'll just play the rest of it afternoon. I forgot that I've got a hard stop for a hearing, but let's press play.
Your Honor, well, just want to share a report that because of the age of this forensic interview, the state would not fast forward it because it is such an old piece of documentation that we don't want the video to reset itself.
Okay. Is part of the 52 minutes the empty room, or the 52 minutes starts only when the interview starts?
It includes
Okay. And how long are we going to look at an empty room?
I think it's just a few minutes.
Okay. All right.
See, that's why I didn't think that's what is it just saying that?
No one asked you to fast forward. I just wanted to know how long we're looking at the empty room.
And you can go ahead and sit, right? I'm gonna see your name right there. Yeah. Do you remember my name from outside? So my name is Miss Monae, and basically it's just my job to talk to you. Sometimes I ask a lot of questions, but maybe it's my job to listen to you, okay? But I want to make sure I'm spelling your whole name right. How do you spell your first name? Q Q L U I A D A R R U. I O O U U S. Awesome. Thank you for helping me get your name right, okay? What's your last name, Cornelia? E U U U L L E U Y. Alright. Thanks for helping me get your whole name right. How old are you? 8. Your age. Do you know your birthday, Cornelia? Yes. What's your birthday? September the 13th. Okay. Tell me a little bit about yourself, Cornelia. Like, what do you like to do for fun? To play. To play? What type of things do you like to do? Like to play? Go see. And go see? What other things do you like to play? Play football. Football. Okay. And we'll probably talk some more about playing in football, okay? Well, while we're talking, if there's ever a time where I ask a question and you don't understand the way I ask the question, it's okay to tell me you don't understand, okay? And you can ask me the same different ways, please, all right? Or if I ask you something, so say I said your name wrong. It's okay for you to correct me while we're talking, okay? Or if you don't know something or you don't remember something, it's okay to tell me you don't know or you don't remember, okay? Just like how you told me you didn't remember my name from outside. Okay, okay. A little bit about the room too. So there's a camera right there, and there's a microphone right there. That's just because the detectives and defects who's helping you and your family, they're just watching from a different room, okay? Just because it's important for them to know what we're talking about, okay? Do you have any questions about the camera? No. Okay. While we're talking too, I promise to tell you the truth while we're talking, okay? Do you promise to tell me the truth while we're talking? Yeah. Do you promise to tell me the truth while we're talking? So you know how I told you the truth about the camera and the microphone? I'll make sure to tell you the truth while we're talking in here, okay? Do you promise to tell me the truth while we're talking? Yes. Okay. So, Darius, tell me about the last time you played football. Huh? So you told me you like to play football, right? Yes. Tell me about the last time you played football. Day before Friday. The day before Friday. Tell me everything about that day. I was running around with my friend. Mm-hmm. And I went to go check on my sister. Mm-hmm. And I went back outside because my cousin was in there with her. Okay. What's the name of your cousin? P. I'm sorry, cousin P. Do you live with your cousin P? No. Okay, so she did general night. Okay. And then you said that they were watching your sister? Mm-hmm. What's your sister's name? Mackenzie. Okay. I'll put Mackenzie first. that was the day before Friday? Yes. Okay. All right. Do you usually do fun stuff with your cousin here and your sister Mackenzie? Yes. What's some fun things that you guys do together? Me and my sister, we used to be playing fight. Play fight? Tell me about play fight. He used to pull my hair. He used to pull your hair. How'd you pull your hair? Like it, great. Okay. When was the last time you guys played fought? I don't remember. Okay. So you said that she would pull your hair. What would you do? I used to jump on it like that. You said you do what? I jump on the leg like that. You tap the leg. Okay. Would that be like with your finger or like with your hand or something? My hand. Your finger. Okay. All right. Okay. So you told me that you like to do football, and then sometimes you like to play fight. What else do you like to do for fun? Run around. Run around? Where do you usually run around? Run around with my friends. With your friends. What's your friend's name? His Monae. Monae. Okay. All right. So when Darius, do you go to school? Yes. What school do you go to? Atlanta Mission. You say Atlanta Mission? Where is it at? I said Atlanta Mission. Elementary? Okay. What grade are you in? Second. You're in second. Okay. How do you like school? Good. Good. What do you like about school? I like to read and I like to write math and I like to say my sight words. Okay. You said sight words? What are some sight words? Like shadow words and things. Okay. Thank you for helping me understand this, okay? How do you usually get to school? My granddad and my grandma, they take me. They take me to grandma. Do you live with your granddad and your grandma? No. Where do you live with? They live down the street, but I gotta be with my grandma right now. Okay. How come you have to be with your grandma right now? Okay. Where your grandma lives? Is that a house, an apartment, or something? Apartment where my mom lives. Apartment with your mom. Okay. And where did you live before you stayed with your grandparents? With my mom. With your mom. Was that a house, an apartment, or something else? Apartment. So you with your partner with your mom first, but now you're with your grandparents? Yes. Who else stays with you at your house, your apartment with your grandparents? Just me and my grandma. You see your grandma? Okay, so you got you, and then y'all you, and then you said grandma, and then the rest is here, grandma. Does anyone else stay with you guys? No. Okay. And you just were staying there. How do you like staying with your grandma? Good. Good. What's good about staying with your grandma? Good. We are playing. You play? What kind of things do you play? Games. Games. Tell me about one of the games. We play Silver Circle. You play what game? Silver Circle. Tell me about that. It's a game where you run and you gotta get the trophies. Oh, okay. Is that like a video game, an in-person game, or something else? It's a person game. Oh, okay. Okay. And then You said before you stayed with your grandma, you stayed with your mom? Yes. Okay. I'll make another U over here. Okay. And then you said your mom. Yeah. What's your mom's name? Jerica. Say that one more time. Jerica. Jerica. Okay, I'll tell my best to spell Jerica, okay? Who else stays with you at that place? Oh, my just me and Mama. I know you told me a little bit about your sister Mackenzie. Where did Mackenzie live? With my mom. With your mom. Is that the same place that you were telling me about? Yes. Okay. Yeah, I'll make a little one down here for Mackenzie, okay? How old is Mackenzie? 1. She's 1. Tell me about Mackenzie. She is a girl, happy baby, and play around. You said she used to be a happy baby. You said she used to. What happened to Mackenzie? She passed away. She passed away. When did that happen? Last week. Last week. Okay. While we're talking to Darius too, if you ever need to take a moment, or if there's something I can do to make you more comfortable, let me know, okay? Okay. Were you there when your sister passed away? Yes. Okay. Tell me everything about that day, from beginning to end. I had been hard. She went through, and I had to go tell my auntie, and she had called the doctor. Mm-hmm. You said your auntie called the doctor? Yes. What's your auntie's name? Kinana. Kinana. I'll put her on a different piece of paper. Where was Kinana? She lived in the same apartment with my grandma. She lives in the same apartment where your grandma lives? Yes. Okay. When did she call? You said your Aunt Kinana called somebody? Yes. Who did she call? The doctor. The doctor. What happened after she called? The people had came to get her, and they took her in the hospital truck. Okay. Is that something you saw with your own eyes, or something else? But but tell me what was happening before that. Before she passed, we were playing. You were playing. Tell me about what you guys were playing. We were running in the house. You were running in the house. Okay. Was that like a morning time, evening time, or something else? Daytime. It was daytime. Who all was home when you guys were running around? My mom. Your mom. Okay. Was anyone else there? No. Okay. Where were you guys running around at? We were around in the house. In the house. Okay. Was anyone talking about anything? No. No. Okay. What happened next? We got the plane. We were in. You said you guys were waiting? I said we were in. You were eating? What were you guys eating? Rice and chicken. Okay. Is that the same thing Mackenzie was eating or something else? Shoot and real potato. Yeah. Okay. So, Was that like lunch food, dinner food, or something else? Dinner food. I know you told me that Mackenzie had passed, but did that happen when you guys were running around before she passed? After, you know? After. That's what you guys were eating. Okay. Tell me what happened after you guys were eating. We had a stop and watched the cartoon. And that's it. Okay. Tell me what happened after that. We had sleep. Go to sleep. Okay, who all fell asleep? And my sister. Your sister. Okay. Where do you guys usually sleep at? In the bed with my mom. In the bed with your mom. Okay. How big's the bed? Well, I sleep in my own bed. And my mom and the kids, they sleep in the bed with each other. Okay. Do you have your own bed in your own room? Yes. Okay. Does Mackenzie have her own bed? Mm-hmm. She sleeps on the side of the bed with my mom. Sleep on the side of your bed with your mama? Okay. Does she have to sleep anywhere else? No. Okay. How do you know they were sleeping? Because I live with everyone and I started to sleep. I came back and I went to sleep. Okay. Was anyone else there? No. Okay. So you saw that they were sleeping in the bed and then you said that you went to go sleep. Okay. Then what happened right after that? Nothing. Nothing. Okay. Tell me what happened as soon as you guys woke up. Then I went in there with my mom again. Went in with your mom? Okay. How come you went in there with your mom when you woke up? I walked in the room, but she never woke. Who was all woke? My mom and me, Kathy. Okay. Do you know what time that was? No. All right. And if you don't know something, you just let me know when there is. It's okay. Okay. All right. So you said you guys woke up and then they were woke in that room because you saw us. Tell me everything that happened after that. The day before it. When you said you guys had ate, you went to sleep. And then when you woke up, you saw your mom and Mackenzie. When you had woke up that day, was that the same day she passed or a different day? A different day. Okay. Tell me everything that happened the morning that she passed. My mom was there, and I had cheer up, but my parents went to sleep, and my mama went to work, but my cousin quit because she's 13, and she was watching us. After all her, she went to bed. I had to call my auntie, and she had called the ambulance. So you said your mom went to work? Mm-hmm. Okay, so mom went to work, and then you said your cousin P was watching? Yeah. Mackenzie? Okay. Where was she watching Mackenzie? We were all in a room. Yeah. What room were you in? In my mom's room. How come your cousin P was there? How come your cousin P was there? How she was there? Mm-hmm. Monae,
Amount of girl. Does your cousin Pete watch McKinsey a lot?
no,
How come she was watching McKinsey that day?
she, I know she was watching her.
Well, how come she was watching her that day?
They both were sick, and I was under my foot. And then I felt my sister, and she wanted to bring me. And I went to go in my room to go get my auntie. I see her call the ambulance.
How come you knew she wasn't breathing?
Hey, her heart was more. She was more, and she said, and I know good better. She was doing a great green stuff.
Showing her green stuff. Is that something you saw with your own eyes? Something else?
So,
Tell me what you remember about what McKinsey looked like then.
she was looking. I don't know.
Okay. What did she have on?
She had on her pajamas.
Her pajamas? What kind of pajamas did she have?
Mickey Mouse.
Mickey Mouse pajamas.
Minnie.
Minnie Mouse. Okay. Thank you for helping me get that right. Okay. How did you know she wasn't breathing? Her heart wasn't moving.
Her heart was moving.
How do you know her heart wasn't moving?
I had checked.
Tell me how you checked.
And her heart was going up and going back down.
It wasn't. Tell me how you checked it.
Like this.
That. Okay. Did you ever touch McKinsey any other time?
No.
Okay. All right. What, when McKinsey wasn't breathing and her heart wasn't moving, what was your cousin Kate doing?
She was in the wood and I had my young room. And my auntie had called the ambulance.
Who's your auntie? Oh, Auntie Kenana.
Mm-hmm.
Was your Auntie Kenana already there at your apartment or was she somewhere else?
She was already there.
She was already there. How come she was there that day?
Because when she had
Mm-hmm.
and shit.
Okay. All right. So you said that Kenyatta called the doctor after she wasn't breathing. And then you said that there was green coming out of McKinsey's mouth.
Yeah.
Okay. Did you notice anything else about McKinsey's body?
No.
Okay. Have you ever seen anything happen to McKinsey's body? Okay. What happened after your Auntie Kenyatta called the doctor?
She went to the ambulance and we all had by the ambulance went there now. And we went there now.
Okay. All right. Okay. So I know you told me that your Auntie Kenyatta was there, cousin Pierre, your mom was at work, but you and Mackenzie were also there.
Yeah.
Is there ever anyone else who's at your apartment?
With your mom? What about mom?
Mm-hmm.
Yeah.
Who else is usually
All from
there? Good friend. What's her friend's name?
Mike.
Mike. Okay, I'll put Mike. Just writing that for the name. Tell me about Mike.
He was nice and he used to take us places.
Mm-hmm.
And he used to take us out to eat. was nice? Yes. Was there any times when Mike wasn't nice? He was always nice, never mean. Never was mean. Okay. How did Mike get along with your sister and your mom? Good. Good. Tell me how he got along good with them. He's Taylor down and he's and my mom down and me and the kids places. Okay, what kind of places? We went to Chuck E. Cheese, then the next day we went to Shiloh, then we had eat, we not eat to go to Korea. Okay, all right. Was Mike there when Mackenzie passed? No, he would leave to work. He would leave to work. Would you leave for work like at nighttime, daytime, or something else? Day. Not nighttime. Okay. All right. You said he was usually nice. Yes. Was there anyone who's never been nice, who hasn't been nice to you and you are Mackenzie? Oh. Okay. When was the last time you saw Mike? I can't remember. Okay, that's fine if you don't remember, okay? Did you see Mike the day Mackenzie passed? No. No. Okay. Maybe. So Quindarius, sometimes I talk to kids about touches that are okay with them and touches that aren't okay with them. Are there any touches that you're okay with? Yes. What kind of touches are you okay with? Where guys, my mom used to call me. So hugs are okay. Okay, so I'll put touches that are okay. So hugs for mom. Are there any other touches that are okay? No. Okay. What are some touches that aren't okay? People who I don't know. Some touches from people you don't know. Okay, I'll put touches from strangers. Okay. What type of touches from strangers would not be okay? I don't know. I walk about, and they trying to knock me off. Try to knock you off. And kiss me. Okay. Has someone ever tried to knock you over? Or touch you? No. But, I like stranger touching. Okay. Has someone you know ever touched you? Yes, Mom. This is my grandma and my auntie. Your grandma and your auntie. What type of touches that are not okay do you get from your auntie and your grandma? They always hugging me. They hug you. Okay. All right. Are there any other touches that aren't okay? No. Okay. So touches from strangers. You said touches are okay from mom if they're hugs. But you don't like hugs from other people. No. Okay. Has Mackenzie ever been touched in a way that wasn't okay with her? These are always okay. Have you ever gotten any touches that hurt? No. Okay. Have you ever seen Mackenzie get any touches that hurt? No. Okay. Have you ever seen more folks get any touches that hurt? Okay. Okay. If you did get a touch that wasn't okay, but is there someone you could tell? No? How come? What? People who I don't know, they used to touch me, but and when they touch me, I ran and go tell my mom. But my mom would be on the right there, and she used to be walking. And I was right there with her, and somebody came and touched me. You said someone came past you? What happened when they came past you? They touched me. How could they touch you? They walked back and had it in my face. They had it, you said they like that to your arm? Right? How did that feel like to your body? Not good. Not good. Okay. And you said you had told your mom. What happened when you told your mom? She started holding my hand, and she said, and she just started holding my hand. Okay. All right. Is there anyone else you could tell? No. Okay. Would you be able to tell like a police officer or a teacher? How come? I do what my teacher do. You said your teacher do? I said, how do my teacher do? How does your teacher do? I'm not sure. Sometimes when I talk to kids, they say that they can tell their teachers if something has happened to them. My mom said, no, she would never tell nobody something. So you should never? Or is something else? No, she never tell nobody nothing when you don't know. Okay. Didn't anyone tell you what to tell me today? No. Nothing. Okay. So, Quindarius, you told me about a little bit about yourself, and then you told me about the day that Mackenzie had passed. Yes. Is there anything we didn't talk about that day when she passed? No. Okay. All right. I do have one more question for Darius, and then we'll take a really quick break, okay? You had told me that Mackenzie wasn't breathing and that her heart wasn't moving. Can you check? Yes. The day that happened, when you woke up, was she not breathing the whole time or something else? She was breathing, and next time her heart won't go down. What was Mackenzie doing before she stopped breathing? She kept on sleep. She kept on sleep. What else was she doing? She wasn't doing nothing else. Okay. Was Mackenzie saying anything? Were you saying anything? Were you saying anything? What were you saying? I was talking about the TV. How people were playing. People were playing on TV. Okay. What was your cousin Pete saying? She was on her phone. Was she on her phone while Mackenzie wasn't breathing or something else? She was on her phone. Mackenzie wasn't breathing. You said she wasn't? Okay. All right. And you said Mackenzie was sleeping a lot. Okay. Does she usually sleep a lot? No. No. Okay. And there's, I'm gonna do real quick. I'm gonna take a quick break, okay? But I'm gonna leave you with some paper. So like if you wanted to draw or you wanted to write something, you can. But you don't have to if you don't want to, okay? Would you be okay with me by yourself for a second?
It's a perfect time to pause. Is there much more interaction after the break?
Very short amount, Your Honor, but there's another question after.
Okay. Ladies and gentlemen, it's noon. I have a hearing in another matter at noon, so this break occurred at just the right time. I'm going to ask you to take your lunch break now. We will resume as close to 1 o'clock as we can. Was an hour enough yesterday? Too long? No, okay. So please try to be back in the jury room by 1. As usual, don't talk about the case, no outside research. Enjoy your lunch break, and we'll see you in 1 hour.
All right, adjourned.
I'm sorry, Miss Patrick, we're gonna have to keep you around. I mean, you go to lunch, but we can't release you yet. Thank you. All right, you all can be seated. Mr. Jordan, anything from the state before we take the lunch break? What is your sense or Ms. McCauley's sense of what we have remaining for the day, just in terms of time? We have Sluss.
So, well.
No.
Detective Sluss is not, he's not texting back, so you know, here at 1 o'clock. We talked yesterday, he said it was fine, but
Okay,
I'm just trying to get him here as early as I possibly can.
yeah,
We have 2 record custodians. One is gonna take longer than the other,
okay,
but I think maybe that'll get us to 2 o'clock, and then I'm hoping to put Sluss up right after that.
great. So that would leave for Monday,
Dr. Costello, Dr. Joe, Dr. Sullivan, our investigator, Sliz, and investigator Smith.
right, okay, that's what I've got. So it would be great if Sluss could be here. Maybe we can put out an all points bulletin for him.
We've already done that.
Great. Mr. Shepherd, anything we need to cover at this time?
This hearing, do I need to clean this up or can I leave this where it is?
You don't, if you could just consolidate to your side, so if Mr. Reynolds' stuff could end up over on your side, will be good. But you can leave your belongings, close your laptop, that kind of thing, but otherwise we're good.
Clean it up.
Yep.
I don't have to pack it all up.
You do not. No, and same with the state, if you could just sort of consolidate it to 1 seat. All right, you can step down, didn't mean to keep you right there, thank you. All right, we are on break for 1 hour. One of the lawyers came in and was sitting there and then wandered out, so I'm assuming they'll come back. Did they? Okay, they should talk, and they can come in. Civil, it's elections. Yeah, so you should, I told them they need their own court report. Oh, can you take down from the screen? You don't need to stop it, we just need to stop the share. I would hate to not have to fast forward or do whatever.
Do you have the timestamps that we should be doing?
I don't know about that. How old is that record? That recording's gotta be 7 years old. Is it on an actual, you were playing a VHS cassette there?
Ms. McCauley had to do some magic to even get it to play on that.
All right.
Found these.
Mine, used?
They have a bunch of used ones, but they're pretty beat up.
Oh.
Yeah.
Good, oh, you found them new?
They have one.
Fantastic, all right.
We're trying to look like.
Oh, you're gonna say?
All right, what is it, 1 team? $1,500. All right. Thank you guys.
22.
I can get there.
I'll come up when we're done. I mean, you'll be able to hear this because I'm just leaving the Zoom going, but I'll have to go up there anyway. So you can just, don't worry about being down here at 1. I'll come up and get some kind of food.
Yes.
Thanks.
I need to address this question to you, but is there some kind of talk about possible PowerPoint presentation if we wanted to use?
I can give you the Zoom link to this feed, and then you can just share through Zoom rooms. Would that work? Does that make sense?
Yes.
Okay. I'm impressed that you have a PowerPoint put together.
It is short.
Okay, that's quick PowerPointing. I will send both you and Mr. Kaufman the Zoom link should you need it. Somewhere, here it is. CG Law Firm, that's the right suffix?
Yes.
Make sure I've got that, okay. All right, Mr. Kaufman, I'm ready. I don't see a court reporter. I don't know if you ordered one up or this is such where we're going to have a conversation and we see what flows from it.
I think we'll probably be at that point.
Okay.
Even I thought the court maybe had the court reporter here. We have one coming up at 1:30 hearing, but I'm fine with it being off the record. That's I think a conversation probably is good to be had.
Okay. So the 1:30 is Judge Farmer.
Yes, sir.
Okay. I'm familiar with the situation. It's just because you can see I have something else going on. The presiding judge is going to handle that. He and I have had a good discussion about that. Okay, let me explain why I think we're here. Well, first, do you have a case number for?
I don't yet, Your Honor. It is a separate case action, of course. I haven't had it hit. I know my office said as soon as it would hit, we would send it to your staff attorney, but I, as of now, do not see one in my
Okay. Well, it is a relative of 24 CV 011-584, which was Adams versus Fulton County, a case that brought all of us together before. And this is, it would be on the same family tree, this case will. And as I understand it, you are bringing litigation, Mr. Kaufman, because Ms. Adams, in her capacity as a member of the county, Fulton County Board of Elections and registration and election, I'm just going to call it the board, but as a board member and thus as a superintendent, she has requested certain election related materials, and the way you set it out in your motion and application, she is being told you don't get those. She has said, well, wait, look what the judge said in the deck action. And then the lawyers talk, and Mr. Siegelman has said, while he loves the deck action order, it is appealed. And because of that notice of appeal, supersedious kicks in, and it's not something that Ms. Adams could seek to enforce, seek to have me enforce, where I would say to Ms. Williams or anyone who works with and for the board, hey, I made these declarations, you need to comply with them. And Mr. Siegelman, in correspondence you included as an exhibit to your filing, pointed out case law many decades more current, and I think more on point about the effect of your notice of appeal of my final order in what we'll call the deck action case. That doesn't mean we shouldn't still talk about this, because another thing that Mr. Siegelman noted in his correspondence with you, I believe, but he'll have a chance to say, no, Judge, that's not what I said, is that your current action, the unnumbered one, also in some ways seeks to invoke one of the two rules, not the reasonable inquiry, but the other one, the you need to give me information rule that Judge Cox has in his order. Really, it was Eternal Vigilance's order that he signed, said those rules are flawed in countless ways, unconstitutional, improperly promulgated, et cetera, et cetera. But that order is out there, and I think it's being appealed. So that is supersedious as well, unless he had an injunctive part of what he did. My ruling was not injunctive. It was a declaration. I had another ruling that's injunctive, but not in this case, meaning the deck action case. So if it's seeking to invoke and enforce the state election board's rule about access to materials, that seems like we can't move forward there either. But then there is just the very fundamental, I'm the superintendent and I have an expansive role that is in some ways ministerial, but in other ways very, very discretionary. And in order to do that, I am entitled to get information independent of a rule that another judge has said is on hold for now. So I still think we need to have a conversation because of that third point. But I want to make sure if you agree with Mr. Siegelman about the state of the law since the adoption of the most recent state constitution and the Appellate Practice Act, et cetera, that the case law you cited, which predates all that, about a judge still being able to enforce his or her own order despite a notice of appeal in place, that's old law, and the current law is really my order in the deck action case is off limits right now. You have made it off limits by saying to the Court of Appeals, McBurney got it wrong, and you need to fix that Court of Appeals. And because of that notice of appeal, it's not something that I can right now wag in someone's face to say, no, I got it right, and you need to do what it was that I said, please.
Your Honor, that's a pretty good high-level summary. I don't exactly agree. I do think the third point is the issue of mandamus on a high level. Notice it was not a motion to compel. It's not based upon necessarily your work. And of course, this Adams lawsuit predated the rule. It wasn't reliant upon the rule.
Right.
I kind of wish the court didn't see the rule as that last little part, although in your order you had mentioned the code.
Well, because that was in front of me, and in full candor, I was prepared to rule that those two rules, setting aside, because the primary attack was their substantive impact, there was a secondary attack, and I don't mean attack in a pejorative sense, there was a challenge to the procedure by which those two state election board rules were promulgated. But setting that aside, my ruling was going to be that those rules mean what they say, they need to be enforced, but what comes before all that is the mandatory nature of certification. And so up to the deadline of certification, you ought to make a reasonable inquiry. You're the superintendent, and you ought to have the materials you need to make that reasonable inquiry. But there is a point at which you must certify. I'm not going to certify because I haven't finished my reasonable inquiry, or this notion that a reasonable inquiry could allow you to push past that deadline because you were exercising your discretionary function. But a different judge made a ruling that we are where we are. So,
Exactly. We of course only appeal the certification component, not even the whole aspect of it.
Yeah.
Of course, it's not for the court. I would know this is a totally, we view it as a related but separate action. I didn't bring this under what I would call Julie Adams 2, where that order came. It's not the same parties.
okay.
It's only Ms. Adams against against the director of elections in her capacity, because these records are her custody and control. And obviously, we still believe the same reasoning of your order, of your declaratory action order is in place. And that's why I don't see this under the same action. We're not dealing with an appeal issue. We could have never even had Julie Adams 2, and I could be running in right now under the exact same mandates that we were doing, which is exactly where we are.
I agree. And to me, that's that sort of category 3, where it's not, Judge, you need to enforce your order, because I think your legal actions have taken my order off the table. 2, it's not proceeding under a rule that has been taken off the table, meaning a state election board, that's off the table. So it would be 3, which if there had been no litigation at all, fantasy world, about the 2024 election, you still could be walking into court today, saying, hey, we've got this situation.
That's exactly right. And that's why I don't think my colleague's analysis is really on point. I mean, it's a great legal theory, but it's got nothing to do with the actual code aspect of why we're here and just adding responsibilities. And again, you don't have commonality of parties. We're not in this level issue or any of these other fun things that we've had to experience over the last month or so. This is specific over, she is entitled to these records. The code says she's entitled to do a diligent search. Some of these records, frankly, should have been out there in the public domain, and they're not even there. For example, the voter list, the qualified voter list, all those things should have been in the public 5 days before the election even started. She can't get them now. And now there's been some overtures of, well, the board met on Wednesday, and you can get some information, but it's going to be not electronic. It's going to be at specific hours. It's going to be what we tell you and when, and that's just not within that discretionary component or obligation. And so she's being prohibited from doing her job under the exact same it's OCGA 21-270 FC that we've been talking about since day one, and is to Ms. Adams' responsibility. So you know, that's where we are. We are in our last day of early voting. 3.2 million plus Georgians have already voted. Over 325,000 plus Fulton County residents have voted. That's a substantial amount of data that Ms. Adams has now been deprived to even analyze. And we're put in the exact situation which sort of brought us to Julie Adams 2 of, hey, now you can get it, or in little piecemeal fashions, but you have to certify, which of course is, you know, something that you know, it's not before the court at the moment anymore, but we're just in this narrow point of, I need to do my job. You have the records. I've asked you for the records. I've had my lawyer ask you for the record. You've gone to a board, a lawyer, and it's not for the board to decide which records Ms. Adams gets in her individual capacity. I think the board was spot on that one. So I'd say you're betting about 500 on that order. All
right.
The whole thing. But you know, in all seriousness, this is an individual capacity responsibility, an individual. It's not for the board to determine, and certainly not for the employee and administrator to determine what information that Ms. Adams deems is in her need to investigate in order to do her job.
All right.
That's why we're here for the next day.
Got it. Mr. Siegelman, let me start by noting a couple things, and then I want to hear from you, just sort of overarching. Obviously, haven't gotten to the substance yet. Number one, thank you for being here on short notice. I appreciate that very much. Number two, so you don't have to say it. I think Mr. Kaufman is shifting his basis for moving forward a bit in his. Got in front of me in the application for the writ. It primarily says, Judge, you should do this because there's an order, the order he has appealed, and I believe thus stayed is the wrong word because only the Court of Appeals could stay it, but it's nothing I can enforce. And I looked at Cooper versus Pollard and Mundy and others, and it's pretty clear that that notice of appeal has placed the order in a nice box that the Court of Appeals can look at and lawyers can argue and dissect, but it's not something that Mr. Kaufman can ask me to waggle in Ms. Williams's face or the board's face to say, you know, I tried to make it clear what needed to happen. So that's off the table. It's actually front and center in part of the application for the writ of mandamus. You don't need to engage on that because I think you're right. Where you ought to engage is whether you think we still need to have a discussion about whether the election director can be directed through mandamus order to hand over certain materials to which Ms. Adams is entitled. I guess the way to flip that around is a member of the board entitled to the types of things that Ms. Adams is asking for. I still think we need to work through that. It's just not as simple as saying, look at the order that flowed from the deck action, because that's off the table. And I don't want you to waste oxygen trying to convince me of that.
Thank you, Your Honor. If it's okay with you, I'll stay seated because given the short period of time, I was not able to summon all the resources that I would like for something that I consider this magnitude. So I'm going to be referring to my computer, notepad, and some notes. I know there's not a court reporter here to take this down, but I think it's worth at least voicing some frustration. The fact that although there is some disagreement between the parties, I have been able to work reasonably well with the council. A bit disappointed that we weren't provided any notice of this. That we don't.
When you say notice of this, what's the this?
This hearing or this matter.
So the hearing, you got notice as soon as I talked with Ms. Niles and figured out this, something needs to be heard and this can't be ignored. No hearing, I think, would be a poor performance by the court. So it's not that I thought last week, hey, let's do this on Friday afternoon. Ms. Niles sent the email out as soon as she and I had finished conferring. I got the email yesterday with things attached to it. So it's last minute from plaintiff's side to you and me, not because I sat on it and let Mr. Kaufman know 2 weeks ago, hey, let's meet at lunch on Friday.
To be clear, Your Honor, not at all critical about being notified by Ms. Niles. In fact, I'm grateful for it because that's the only way I learned about this.
Okay.
But having been involved in this, clearly this being noticed as filed as a related case, that it's a bit disappointing that this would have been shared with the court but not shared with us. And then even when Ms. Niles notified us, I had to ask for a copy of the petitioner application. On the eve of a hearing when that amount of time, not being able to look at it until 9:30, 10 o'clock at night is a bit frustrating.
Right.
So I want to voice that.
Okay. It's heard.
Thank you. And also, I appreciate Your Honor's framing of this. I do disagree somewhat with how you framed it because although Your Honor might agree that a stay or supersedeas is in effect and that limits the ability to enforce, prevents the ability to enforce an order, what that means is important. And I think it is important to talk about exactly what a supersedeas means, what stays are in place, what the law actually is in light of those stays. And so that's the PowerPoint. I do want to go over that. Another point here is the goalposts with regard to this particular plaintiff keeps changing from Adams 1 to Adams 2 to now this action. And we are less than a week out from the election. At some point, we need some sort of stability and some sort of understanding. I'll give you an example. Ms. Adams made a request of Fulton County Board. She got everything she asked for. She didn't get it as quickly as she wanted, but she got everything that she asked for, and she was given ample opportunity to review it. That's something she in fact acknowledged. Now she wants more things more quickly. She wants them in a different format. So we are doing everything that we possibly can under the circumstances to accommodate Ms. Adams.
So let me pause you because that sort of gets to the heart of what I think we need to discuss today. And that is, are there any times that you're aware of where Ms. Adams has been told no, or has it been Sure, when we can, because they're very, very different answers. And given that this county has been processing so many hundreds of thousands of early voters and everything that's going on, and there's so many wheels that are spinning to have Tuesday ready to go, to me, it's unremarkable and not particularly troubling if the answer that Ms. Adams has been given, we're working on it, but we're working on a whole other thing too. We don't have the Adams Rapid Response Team as part of the County Election Commission. And I'm at peace with that if that's the answer. If the answer is no, that's what I want better understanding on, because no to me seems problematic given the roles that people have here. And what you described so far is it was a yes, here you got it. It didn't come fast enough for someone, but the answer was, of course, you can have it. You are a board member. You can have it. We're working on it. And maybe it came this way and it should have come that way, or it was comma delimited and not an Excel file. Okay. Nonetheless, the data was provided. So that's really what I'm trying to suss out, because I do believe that if you and I had never met and there had been no earlier litigation, Ms. Adams could still be knocking on this door saying, I am a superintendent, I'm a member of the board, I'm entitled to this information, and I'm being told I can't have it, because that is how I read this emergency application.
Yes, Your Honor. So we need to read the emergency application for what it says. I understand that we're trying to make it a little more valuable for this court's comments a moment ago. But I think the relief that's being sought is important because, for example, Your Honor, this is not meant to be critical of you, but the relief in your order that we're here to talk about was not actually requested by Ms. Adams. It was given by this court in spite of it not having been requested. So I think it's important, especially in this matter, that we do look at exactly what she's asking and try to, either give her what she's asking if it's possible, or recognize that it's not possible. And I don't think that we need to ourselves change that to try to create possibly more issues that could be avoided. Okay. So to answer your question, Your Honor, unfortunately, we do have to figure out what the law is. Because in your order, even if it's, we seem to be in agreement that your order is of no effect here, but even if we look at your order, it says, and what I understand Your Honor is saying is that if she makes a request for documents, you can entertain that, and also, but if it's protected by disclosure from law or other reasons that it shouldn't be.
That's what it said.
Even if we extract that from your order and we play with that and we say it's not part of the order, it's not part of what's being enforced, I think we need to figure out what exactly that means, because only in that context, which is the entire basis of this action, can we determine whether what she has requested makes sense and whether or not she's entitled to get it and what time frame she's entitled to get it. So if you will, I don't know if you can see this.
I can. Yes.
See if I can get full screen. Whether I can or can't. Let's see. Okay. It's full screen on my computer. There we go. So we need to look at specifically what plaintiff is seeking here. And although the court has invited us to possibly change that, I would argue that we should not. And what she asked for is specifically for Ms. Williams, not the board, Ms. Williams alone, to quote unquote comply with the final order as issued. So the relief she's asking is for enforcement of the order. That should not get lost. The other is, as we've already talked about, she wants her cake and eat it too. She is filing a notice of appeal, which stays the order. Yet she is here saying, no, enforce the order that I myself have stayed. That we believe is a problem. So I will go through this quickly because Ronald has already addressed this. It is stayed. You understand that?
I didn't mean to gut your PowerPoint. Like I said, I'm still impressed you did a PowerPoint in this short amount of time. You just also, in your email to Mr. Kaufman, said see Cooper versus Pollard. So I read Cooper versus Pollard, the cases that led to it, and it was a good citation. It says what you said it says. So I get this.
I try not to misrepresent the court. Certainly wouldn't do it intentionally. And thank you for being prepared and reading it, letting us get through that. I will not worry about the PowerPoint, but this part of the PowerPoint, I think, does still need to be addressed. So even if this court wants to move past the stay and supersedious that we all acknowledge is in effect.
But let me tell you why I talked about that. In looking again at the emergency application, I am agreeing with you that it seeks to invoke the order that flowed from the deck action. And that's not a relief or remedy available to Ms. Adams because she has elected to appeal it. That's the whole point of your first few slides. I didn't appreciate, as in follow so closely, how heavily the emergency application relies on final order. We all got to do what the final order says. I like that. You ought to, but that final order is not in place right now. And so it's not mine to say, why don't you do that? For the reasons you cited. So here, this is the reason why I interrupted you. I agree with you. I enter an order that said, I can't give you the relief you want because the final order is taking a break until it is warmly embraced by the Court of Appeals or tossed into the garbage can. Aren't we going to be back together on Monday? Mr. Kaufman and his legal team has an amazing ability to react and reform their pleadings. And so there could be an emergency application for writ of mandamus that on Monday we're dealing with. It will come to me because it's a related action, but it will be premised on whatever root obligation, statutory, regulatory, whatever, the board staff has to give to a board member information that she requests.
First thing
So you can win today, but then we have to talk about it anyway.
Well, the first thing I'll say, Your Honor, is you may come to regret suggesting additional legal actions that this plaintiff should consider because there are enough.
I'm confident that
I might suggest keeping those to yourself.
I'm confident that I don't need to, that I haven't said anything that hasn't already been contemplated, but keep going.
And again, not to belabor the point, but we're here over language that arguably that wasn't relief sought by Ms. Adams in the first place. So I do think that shouldn't get lost. So to your point, and that's exactly why these slides are here. If we move past this stay and supersedious and we say, for instance, that is not dispositive here, but we want to go further, then we have to figure out, okay, what exactly is the law? Okay, the order's not in effect. Okay, well then we need to know what the law is. Okay, so your order cites to OCGA 21-270 subsection 8. Uses a quote there, but it also refers to a regulation that has since been invalidated, as you acknowledged, by another court, and that has been upheld at least temporarily.
Sure, that's the law.
That is the law. So although your order cannot be given effect, with all due respect, Judge Cox's order is still in effect. So we need to look at what Judge Cox's order says with regard to the regulation that Your Honor cites. Because even if you remove the citation, you cited it because it's relevant. And so we must see what relevance, if any, Judge Cox's order has on this matter. And I've used the word at the top of this page, and I appreciate Your Honor's acknowledgement that I try to be very direct and candid and not exaggerate or misrepresent the court. We believe the final order has not just been stayed, but in fact superseded by Judge Cox's order, and I'll explain to you that why in the slides. So all of the prior slide was just the pertinent language that Ms. Adams seeks to.
How would one Superior Court judge's order supersede another Superior Court judge's order? Let's say Judge Cox had issued an order that said certification, I'm not even use his name. Let's say another judge in Fulton County issued an order that said certification is discretionary. But it came out 2 days after mine that said it's mandatory. It doesn't supersede anything. It is why related actions ought to be consolidated, and that would be a reason for an appeal so that a higher court could reconcile two different perspectives. But I'm not aware of the authority of one Superior Court judge to do anything that would say what my colleague said is superseded, reversed, removed, destroyed. They could throw shade, And that's not here at all. It's just that there were slightly different issues, and what was before Judge Cox was more expansive when it came to the state election board rules. What you and I and Mr. Kaufman were dealing with dealt with the dynamic on a local election board. So I don't want to get into too much of it, but I don't, you need to help me understand your thinking of judicial authority, where one Superior Court judge can do something that makes what another Superior Court judge did superseded or invalidate.
They can't, you're right.
Okay.
And it's not his order in and of itself, it's the fact that his order has been upheld by the Supreme Court and your order is stayed. So my point is, if there is any contradictory language, if the order that Judge Cox issued conflicts with your order, his order should be given effect because it is the law and still in place, whereas your order is stayed and can't be enforced.
Okay, I mean, I guess it's sort of academic. My order has no effect right now anyway. So the only order that's in effect is Judge Cox's, which says nothing about whether, I believe, whether a board member is entitled to get information from the people who work for the board.
So let's look at, and if you continue to disagree after my next was two sides, last slides, excuse me, maybe need another sip of water. Happy to have that discussion.
Okay.
But let's work through this and you can see what I mean. So this is the language. And I will say this, Your Honor, to the extent the superseded language is not exactly accurate, my point is simply that we have an order in that you issued, Your Honor, respectfully, that is not to be given effect.
Right.
Maybe some underlying reasoning should be given effect. The order itself can't be given effect. Judge Cox's order can and is the law. So that's my point. And it's not the law because he says it is and he can override you. It's the notice of appeal that stays yours. That's what does your case.
Sure.
And it's the Supreme Court, allowing the Judge Cox order to stay in place that allows his order to take effect. Okay, that's all I'm saying.
Yep.
So if the language is wrong there, I apologize.
It's okay.
So here is the pertinent language regarding now it is in the context of this regulation, but let's look and see what exactly Judge Cox says in his order. It says that the regulation 183-1-12.12 which states that all election-related documentation created during the conduct of elections prior to certification of results should be made available to any individual member of a county board of elections. I think Your Honor would agree that setting aside the actual citations, whether it's the regulation or whatever, that is exactly the remedy that Member Adams seeks to obtain in this action. And Judge Cox says further that language, that belief, that assertion is directly inconsistent with the election code, which provides the time, manner, and method in which election-related documents must be produced and maintained. He cites a code section there, 21-493. The SB rule, again, stating that individual members of a county board of election shall be able to receive all election documentation prior to certification of results, creates a statutorily unbound scope under which superintendents can consider unauthorized materials when tabulating, canvassing, and certifying election results. Thus, this provision, again, which states that individual county board members can receive all election documentation, is void as it is inconsistent with statutory framework, void and unenforceable. So, although this language in this ruling is in the context of specifically this regulation, the language and the interpretation of the law is in effect and does respectfully, Your Honor, take precedent over your rationale or interpretation that to the extent it conflicts, because your order is not in place, Judge Cox's order is. So we already know this, won't belabor this point, but the Supreme Court of Georgia denied the motion to supersede the emergency motion and denied the emergency motion for expedited review, which is why Judge Cox's order remains in place. So to discuss again, perhaps a cleaner, clearer format, Judge Cox's order ruled that election boards are not required to make available all election-related documentation, prior to certification, because doing so would be directly inconsistent with the election code, which provides a time, manner, place, and method for which in which election-related documents must be produced and maintained. Thus, election boards shall not supply individual board members with all of those materials, election-related materials created or conduct of election prior to certification, to ensure, and I quote, that they do not consider unauthorized materials when tabulating, canvassing, and certifying election results. That is the law. As of today.
At the Superior Court level. So I don't know that it binds me, but it's good to know that it's out there.
Well, the Supreme Court has temporarily signed off on that for the time.
The Supreme Court hasn't gotten in the way of that for the time being.
Well, agreed, Your Honor.
Okay.
But again, to the extent you disagree with the rationale, you can go outside your order if you want, but again, this action seeks to enforce an order, which is, on hold, and it's directly inconsistent with an order that is not on hold, that has at least been sanctioned to remain in place by the Supreme Court.
Tell me how you get I'm intrigued by this slide. They should be provided, but not prior to certification, because that would allow them or could create the situation where they're considering unauthorized material. I mean, who defines these terms? What's an unauthorized material? I guess the lawyers for eternal vigilance define whatever unauthorized materials means.
Well, I would ask the cops, because those are his words. But the reason I frame it in this way is because in your order, to the extent you believe you can give it effect.
I don't. You don't need to refer to my order. I can't give it effect right now. So we don't need to worry about the deck action order. I'm not so sure we need to worry about this order either, because I don't know that it controls another Superior Court judge, but I certainly wouldn't want to do something that is inconsistent with the Electoral Code. And that's the sweeping claim in the order you're relying on, the only order of the two we're talking about that is in effect. And so I'm trying to understand what's an example of something that it would be unauthorized for a superintendent to be looking at. That's the kind of thing that escapes me, is this notion that there are things that is okay for people who work for a superintendent to be looking at, but the superintendent can't look at it. That to me is a strange scenario. You have to certify, but you can't look at, we're looking at these things. We work for you and we got it, but you can't look at that. You can only look at these things. I don't think that's what the election code says. I think that one provision that order relies on, 493, speaks to certification, but we all know that election superintendents are responsible for much more than that, see 70 instead of 493. And so if the request from a superintendent is, in order for me to certify, you have to give me these things, there could be some pushback to say, well, 493 talks about that. But if it's not framed in, I need this in order to certify, but I'm a superintendent, give me this stuff. Hopefully it's asked for more nicely than that. The notion that someone who works for the board and the superintendent could say, nah, trust me, you don't need that, or you can't have it. With one exception that was brought up in one of our hearings, it may have been by you, it might have been by the Bondurant folks. Wait a minute, you don't get like voter information. You don't get to know that Siegelman voted for Jill Stein. It's just, that's secret. You don't get to know linking the name of an elector with the outcome, but maybe you can look at ballots or this or that. So I get it that certain things would fall under this category of unauthorized, but that seems to be narrow to me, that it would be narrow and pretty common sense. Get my social security number, or again, linking an elector to a vote, but almost anything else, it seems like it's telling the manager of the team, you don't get to know the stats for your leadoff hitter. You're gonna need to decide whether you want him to keep leading off based on what I give you.
Your Honor, I think I understand what you're saying is that you may or may not be inclined to sort of give effect to Judge Cox's order. This slide, just to explain what it was, is to read the reasoning, not the order itself necessarily, but to explain to read them consistently with one another. If documents are pursuant to 21-270, they're not for certification, they should be provided, they should be provided promptly. But if you're reading it consistently with Judge Cox's order, that doesn't necessarily mean during this very constricted time of certification, because it's not necessary for certification and could lead to viewing unauthorized materials in the words of Judge Cox. I understand I disagree with that. That's the reason why it's slide.
I don't disagree. I have questions about it. I'm just trying to understand, and I the way it works isn't to say to the person who asks the question, oh, you got to go ask the judge what he or she meant by that. I mean, the order says what it says. And if the word unauthorized isn't defined, then the practitioners, and right now that happens to include a judge, need to define what unauthorized mean. And what I'm searching for is your thoughts on what would be unauthorized. I gave you an example that seemed pretty commonsensical to me, that again, linking an elector to an actual ballot, don't do that. But beyond that, I don't know what would be unauthorized for a superintendent to have. You touched on the point that I thought was going to be the thrust of your presentation, which is, hey, the election is on Tuesday, and we are happy to get any superintendent what he or she asked for, but you got to get in line. And there is sort of this prioritization that has to occur. And that to me makes more sense, where someone who works for, maybe at the pleasure of the board, would say, I can do this for you, but there are all these other obligations we have statutorily, and those have to be taken care of. And then I can get to getting you a photocopy of the postage on every mail-in ballot, so we know that the stamp on there, that it was date stamped by the right time. Yeah, I get you that, but I can't right now unless you can figure out how to get from the county another $1 million so we can create this rapid response team to get you the data you want.
So, Your Honor, agreed, and I think it's important to note that at no point, my knowledge at least, has the board told Adams no. There's always been, we will get you as much as we can and when we can. That has been the consistent theme through all this.
Okay.
I will say, Your Honor, that my understanding of these mandamus actions is that Your Honor will decide whether this can proceed, and then there will be a hearing where we can discuss exactly what can be made available when.
That's the dilemma we've got with timing. And today, clearly, it's not appropriate to expect you and the client you represent to be in a position to answer that. But it's also Friday, and the election is Tuesday, and certification is just a few days after that. So I share your going in comments about why are we talking about this now?
So
but we are.
I did think framing the law as we understand it is important. The other point is, like I said, that we're here about a mandamus action, and mandamus action is quite notoriously only available if there is a clear legal right. I respectfully disagree with opposing counsel's framing. They've only named Williams, the election director. The board is who made the decision with regard to the documents that will be available when. Essentially, this court would be in a position of saying, elections director, you must defy the board and what they've told you to do. And it would also strip the board of any sort of discretion that they have as to prioritize what gets done when. So
it would be sort of I don't know the dynamics, and I got to give Mr. Kaufman a few minutes before we run out of time as well. But the way you're framing it, as I understand it, is that the board voted, and the vote was, Ms. Williams and team, here's how you're going to move forward. Here are your priorities. You got to do it this way. And if I were to enter the mandamus as it's requested, one, it would require me to invoke an order that's not in effect and invocable right now. But two, it would be me saying, Ms. Williams, I know your boss is probably the wrong word, but structurally, the entity that is in charge of elections in Fulton County, the board, they told you to do X, ignore that. I need you to do Y. Even though the will of that board was to do X. And so the mandamus maybe ought to be the board, you need to make sure each of your members has access to things, and not the person who's merely effectuating what the board through a majority vote said to do.
Well, and it would be careful suggesting perhaps again another action or do.
No. But am I hearing you correctly that if we had a hearing and there was testimony and Ms. Williams said, the reason why I am not doing what Ms. Adams is asking for at the speech she's asking for is because the board, in other words, more votes than Ms. Adams had, said, don't do it that way. I may be simplifying it, but it's not Ms. Williams saying, no, I'm not interested in doing that.
That's 100% correct, Your Honor. Without there being a clear legal duty, there cannot be mandamus. And I think part of walking through what the law is this order being stayed, competing order arguably with at least inconsistent language regarding election materials is still in place, which is in Fulton County, even though my client wasn't a party to that particular action. That is the law in Fulton County, so they are stuck with it just as much as yours, except yours is now been lifted. So
Right. Mine binds no one.
So that lack of clarity in the law, I think alone precludes this type of relief, because it cannot be said that it is clear specifically what she should get, when she should get it, when promptly means, and what promptly means.
I guess, I still, and we're not gonna be able to get to it today, but, no one has been able to show me what in the electoral code, not rules, nothing from the state, but the law passed by the legislature says a superintendent may not have certain things if the superintendent says, here's what I need.
Yeah, Your Honor, that is an important point. I don't think at any point she's been told, no, she can't have something unless it's like she wants unsealed ballots that she can't unseal.
Right.
So it's always been, we can make this available for you on X date under, certain parameters.
Okay. You've sort of said it in two different ways. What you're saying now resonates much more with me. You've also said, well, there's stuff that's unauthorized and this and that. Okay, that's what your slide says. I didn't pick the words on your slide, okay? That's what you are saying is out there. And I'm more focused on what the electoral code says than what that order says. And you sounds like we're in agreement that there is not a provision in electoral code that says superintendents can have this, but not that, with the exception of what I'll call PPI, personally protected information, unsealing a ballot. But it doesn't sound like, because this is what you would lead with, doesn't sound like that's what Ms. Adams is asking for. That I want to open up each ballot and look at it and all that. It's voluminous, it's cumbersome, it's not easy to get, but it's not that it's unauthorized. It's the timing and maybe the scope of the request that's proving difficult to comply with, and then resulting in a lawsuit that makes it sound like she's being told no.
Well, and I think that's exactly right. And the only point I was making about clarity and mandamus is there is no clear guidance on exactly this particular piece of election material must be available at this time, which would be a clear right. An order saying that this must be turned over at this particular time would strip the board of its discretion to complete this.
No, and it would be inserting language into the electoral code that doesn't exist. So I'm just looking at it from the flip side, and I think it's pretty clear from the electoral code that things may not be withheld. It's just the question of when it happens. But I hear you. I'm not disagreeing.
And I do want to point out one statement by opposing counsel that the voter list should be in the public. I'm fairly certain that the Secretary of State has it and it is available to the public.
Okay, I don't know, and I'm not going to get in the middle of that. That would be the level of granularity that we would get into if we were having an evidentiary hearing, which the timing of these proceedings doesn't allow. Okay, Mr. Kaufman, you listened patiently. One time you stood up, but you wisely sat back down. It was Mr. Siegelman's turn. I'd ask you to focus on, because we covered a lot of ground, but I think it was appropriate because you've had the benefit of filing the application and being ready for it. And Mr. Siegelman is very much playing catch up. No fault of his, just the way this is flowing at this time of year in this election cycle. One thing that I pried out of Mr. Siegelman is a claim that there have been no no's to Ms. Adams. In other words, she asked for something and the answer is no, as opposed to just a second, in a minute, in a day. And it doesn't, I'm not right now interested in the time frame. I'm focused more on the, has there been a categorical, you may not? And if there has, was that actually a board action? The board voted 3-2. You know what? We're not going to pursue that right now. And then we get into a very different dynamic about what a board vote means and what a board member can do individually. So two pieces.
Yes.
Has there been a no? And if what you perceive was a no, did that come from Ms. Williams or Mr. Jones or Ms. whomever who aren't board members? In other words, speaking up to the board saying, nah, you can't have it.
I'm following.
Okay.
Well, first of all, not much more time. We filed this at 4 p.m. yesterday, so we of course didn't know if the board was gonna hear it, Judge Farmer was gonna hear it, or no one's gonna hear it.
Yeah, Judge Farmer is already doing me a solid with you in a half hour, so
exactly.
I said that.
It'll, whatever.
Okay.
I just don't want that situation. The answer is, she has been told no. And she's been told no from administrators, as well as this now board collective action that occurred on my understanding based upon what I'm picking up from the board. What I agree, it was faulty legal advice, is that, look, we're not bound by it, we've got Judge Cox order. Of course, Judge Cox order is only under a SCB rule, under pretenses. He cites OCGA, we went back to his slide, it was actually 21-279, which was to receive from poll officers the returns of all primaries and elections to canvass and compute the same. And then he talks about 493, which of course is post-voting period.
Right.
Which has nothing to do with any of these issues. And so.
Well, it has something to do, but it doesn't cover the waterfront, which is what I was discussing with Ms. Siegelman. But
right.
Give me an example of a no, and I don't mean here's who said what, but what's something Ms. Adams asked for, and then specifically was the response, you may not, or it was, we'll get to it?
Well, I may need a little help from Ms. Adams.
That's fine.
But again, the qualified voter list of electors should have been published.
Well, published is different from give it to me.
Well, that's the whole point. It should have been in the public domain.
Then she wouldn't need to ask for it.
And she can't even get it.
Okay.
Because it's not there. We were told the enumerated voter list. Well, which should have been out there. Go ahead.
What is an enumerated voter list?
The number voter list, all types of voting. So it's lists of the voters who've cast ballots so far, how absentee election day, how they voted. That's something they should be doing daily. That would be your ask. And how they voted, exactly, absentee by mail, absentee in person.
Got it. Okay, so those types of running statistics that superintendents ought to be keeping up with, I think they're required to report them regularly.
And if she had digital access, which she requested, denied.
And denied, so denied meaning when we figure out how to do it, we'll do it, or it has simply been
you electronic access, because that's all she wants.
explanation for why, or just no, you may not?
Hi, not from the superintendent, she said she helped.
So we'd have to check the legal.
Okay, and legal means the county attorney? Not, there's not a lawyer on the board.
I believe there is one, but my understanding is all being run through county legal and then outside counsel.
Okay.
A list, Adams asked for a list of the complaints from poll watchers, poll workers and voters that have been made, that have gone into the SOS as an actual, just going a list. How's it been done? How was it handled? Things you would think would be readily available, probably be taken in real time if the county was watching it. I also just want to point back out to the Judge Cox issue is that it was only 21-270-9. There's 8 other provisions ahead of it and 5 other behind it, which are all with the court. And of course, we spent a lot of time on the whole citing the order. Obviously, we're aware of the order aspect, but your logic and your reasoning, and especially before it's a related case, is clearly there's nothing that has changed that reasoning for this court of certainly equal jurisdiction to Judge Cox's, and I have pretty confidence that I'm not sure that order, Judge Cox's order will stand once the Supreme Court handles it. But we are where we are. But I mean, yes, we're under this time constraint, and that's sort of the problem with having this. But these are basic things that she's asked for that I don't think are outside this realm of they haven't said we can't do it. And then the idea that you would then go to a board for that board to constrain individuals' duties and responsibilities, we take issue with, especially in the political dynamic of where we are.
Sure. No, I appreciate that. But tell me a little bit about that, because if the board has voted and issued a directive to Ms. Williams or others that is contrary to what Ms. Adams is seeking, isn't the relief, doesn't that complicate the relief? What is the role of the courts in going around the democratic process, if you will? I don't know the dynamic, but let's say there are 5 members of the board and they vote 3-2 to say, we are instructing Ms. Williams and the people who support Ms. Williams to table any request for information from a superintendent so we can stay laser focused on, and it's a very long list of things we're doing. If the board votes 3-2 to do that, why would it be appropriate for the courts to come behind that and say, I'm gonna issue a mandamus compelling Ms. Williams or anyone else to do these things that might be authorized by the law, provide this information to the superintendent, when collectively the superintendent, 3-2, 4-1, majority vote, said, that's not your priority right now. And there's nothing in the law that says the collective superintendent couldn't do that.
Sure, I think I can address that. I mean, it's complicated. Again, we've heard lots about the history and how you had one superintendent back in the day, and then we've had a change because there's boards, and the boards get created by county, which is of course less than what the legislature creation. I think the issue is, one, their reasoning in the executive session was because of this order, which is wholly flawed.
Yeah.
Two is the legislature does not differentiate collective board action from individual action. And in fact, to the extent it does differentiate, it talks about an individual board member's duties and responsibilities. And so I would argue that because the legislature has specifically enumerated those and have never addressed collective responsibilities, that having an individual employee, who by the way is not even a real, it's sort of a messed up situation because they're not, the administrators are not even real employees of the election board, because you also have to deal with the county commission, who's the one that can ultimately decide who's hired and fired in an integrated system. The other thing you mentioned about the democratic process, it isn't. These are members of a board that are put on by both parties, where it's always going to be 3-2 in Fulton County. So it basically there's nothing in the law that.
What I meant by democratic, that was lowercase d. If there's a group of 5 and the way they figure out how to move forward, if that's their charter, is we take a vote, 3-2 is how you move forward. And if 3-2 or 4-1, if a majority of the group that has been appointed in whatever way they get appointed, and they're properly appointed, and there's nothing funky about the vote, and it's not a secret meeting where only 3 people show up and the others don't know there's a meeting, and 3-2 they vote and inform the team that supports the board, we're not gonna prioritize doing this stuff.
And I think you're talking in terms of resources, right? Not yes or no.
Correct.
And not of when and how. And that's problematic, because we haven't heard, oh, we don't have resources. We've heard, no. We've heard, well, we disagree with the order. We like Judge Cox's order better. We'll just completely ignore most of the rest of the code under OCGA 21270, except for the one part that's maybe convenient for us. We haven't heard that. And what we've done is now waited and sandbagged until we're now at the point where you have over 325,000 votes and she hasn't gotten to see anything. And then they're going to say, oh, Tuesday's huge turnout and now you have certified votes. And so she's been prohibited from doing her individual job. And I don't think there's anything in the code or anything in the Fulton County enabling legislation that says the collective board action can restrain her individual responsibility. And again, going back to the oath and to what the legislature wrote in, it directs her to do that in that individual capacity to the best of her ability. Now, if you have no ability, because a Democratic low D board decides that you're just going to be handcuffed to decide what is important or when you're going to get it, that's there. And the answer on the resources thing is that's for Fulton County to make sure they have enough resources on today. That's why they've been given the responsibility and the ability. The legislature gave them the ability to set that off. And I imagine the legislature after this year will very much look at this entire process. So you'll see what we get.
I bet they will. They probably will start with the state election board and work their way down. All right, I appreciate that. That's very helpful. Mr. Siegelman, again, today is an evidence day. I don't know when evidence day would be, but we already have a conflict in the evidence purportedly. We never said no. I got several no's. Anything you want to do to help me better understand that inconsistency?
My colleague will address some of that.
Hi, colleague. Hey, Ms. Warner, thank you for being here.
Since you got this late last night. So
Me too.
I'm playing catch up as well.
All right.
Are you a few very specific focus points to address exactly what I think you're asking for. On the electronic access, for example, the board determined that was a security issue to give her own set of login credentials.
And when you say the board determined,
That's my next point.
Okay.
The board took a vote and decided, and this is, I've been gathering information while y'all
Yeah.
talking. So my understanding is that the board took a vote and decided that none of the individual members of the board were going to get individual logins and electronic access.
it's not that 3 of them do and 2 of them don't. It's a no one because of the security concerns.
Correct.
Okay.
And then another example with regard to the list that he referenced. The board agreed to give her the list. They agreed to give her the list before certification, but it wasn't in the form or as quickly as she would have wanted. So again, not a no, but a disagreement.
Okay. When you say the form, I know we're getting technical here, but I'm just curious if she asked for it in an incredibly rare, difficult to format approach, or she said, could I have it electronically? And the board said, no, but we can give you a 19-inch high stack of paper.
It is not the latter, but I also don't believe it was the former where she asked for something so bizarre.
Okay.
I think in some of these instances, and I'll give you another example, she may have requested documents from the board that actually rest with the Secretary of State. So in order for the board to put certain materials together, they gotta go to the Secretary of State.
Mr. Siegelman's example that there could be voter lists that are actually SOS documents, and being responsive to a board member, hey, staff, we'll go do it, but we're actually going out of house in a way that really the board member could. You know, if you're really interested in that, and you're so well supported with a legal team, maybe your legal team could go to SOS and get that information.
Right, and I think the point here and what the board would say if they were asked, like capital B board and capital S superintendent, as the rule refers to the collective, is they're trying to figure out an orderly process to deal with these requests and to respond to them in a way that doesn't interfere with their ability to carry out their duties, that addresses her issues, but that alleviates what's happening now. The pragmatic issues are like every other day, come in, request. We can't get to this. Okay, you're refusing to give me what I asked for. We're gonna have to report. We're gonna get lawyers involved. It's a disruptive process. And so they've been trying to figure out a reasonable way to get this done, and it hasn't been a no. Unfortunately, I think she's heard it as a no, but it wasn't a real no. It wasn't not right now, or it was we can't get that together the way you're asking for, or there are other things we have to do, or there are other things that we as a board need to consider together.
Sure.
So for example, you may not get your own individual copy early, but when we get it all together, we'll sit down, everybody will have access to it, which is compliant, you know, and everybody will be able to make whatever determinations they need to make to meet their obligations.
Given the frustrations that Ms. Adams had during the time of the presidential preference, which was many months ago, are you aware if she months or weeks in advance said, hey, this is the kind of information I'm gonna need? Because we know November 5 is a big day. And so no one's having to scramble because I'm asking you on November 1 or October 31st. I'm gonna ask on September 1. This is the kind of, because it's not a surprise how, other than will there be hand counted ballots or not, and there won't. There's not a surprise about the flow of information. And so I'm curious if Ms. Adams or any other member of the board said, hey, it was just Labor Day. I'm realizing we're getting closer to the elections. I don't want to be bombarding you daily or every other day with new requests for things. So here's what I need. And so you know far in advance, and so you can prep for it. And I'd like electronic access, and if I'm told no because of a security concern, we're gonna bring someone in a month in advance to address that security concern. Is that how it has flowed?
No, she's not.
Okay. Thank you. Why didn't you let Ms. Warner start? Dang. All right, thank you. You're very welcome. I appreciate you being here as well. Mr. Kaufman, I want to give you the final word as the movant. Anything more you think I should know before I pivot back to the murder trial?
I want to leave you with one thought on this, just so you can kind of understand the absurd position that you put in. So they say, oh, well, we're going to go show you this information. You're going to be alone. You won't have a computer. You won't have your cell phone. You'll have no electronics. You can only compute whatever you want with a pen and paper with these kind of volume in this limited period of time.
Right.
I mean, she's the boss. This is employees or even her other fellow equal level bosses. Remember, the chair has no other greater authority. She's just one of the five.
Right.
But everyone's going, oh, you gotta ask the chair decides. Well, that's not true. And so this is what we're dealing with in the largest county in our state. And so the fact that she's not given that opportunity to have realistic access and realistic ability to understand it is really the problem and why we're here. We don't want to be here. I it's an email trying to work it out. We were told in open court, oh, we're going to make sure we do it better. And I remember I made a flippant comment. I said, well, the past is a great predictor of the future, and yet here we are. So that's where I want to leave the court. Obviously, time is of the essence. I think we bet the immediate irreparable, not really compensable money, not about the public policy components of what a mandamus needs. I guess the real question to me and for us is what are we going to do about it if we do have to have another evidentiary hearing on specific matters to be heard, be requested and provided?
It's a good question. I don't have an answer for you. I'm in the middle of a murder trial. So we will, I need to process everything I learned from all the good lawyers here today. And of course, I'm confined to the four corners of the document. And I will address that. I will also need the clerk's office to give us a civil action number. But if we need to meet again, it's going to be on short notice. One, because there's not lots of time for Ms. Adams to continue to try to do the important things she's trying to do for this election cycle. Everyone has competing demands on their time as well. So I will work through that as best I can.
And I still don't see a filing as well as just checking.
Okay. I will reach out to my staff to see if they can expedite this. What will be in the docket so far? Just the emergency application?
Yes, Ron, that's the only thing that's been filed.
Okay. All right. It's not changing what I do. I want to be clear. I understand the issue that's before me, but I also appreciate Mr. Siegelman's request that instead of thinking about ways it could be pled, I focus on how it was pled, because that will shape what I do this time around. I just want to end again by sharing my appreciation with all of you for being here on short notice, even putting together a PowerPoint. You're at no disadvantage, Mr. Kaufman, because you didn't have a PowerPoint. I just thought it was kind of smooth that he had him pull one together.
I actually had my iPad, but I remember the last time we had this technical side, I just opted.
It's all good. You didn't need one. You made your points very well. And it is good to see Ms. Adams and Ms. Williams again, and maybe we'll bump into each other not in court sometime. And you all are busy. Go back to do what you need to do.
I'm going to see Judge Farmer now. But
Yeah, good luck with that one.
thank you, Ron.
Mhm. You all are welcome. Yeah, well, that's what I told the court reporter. I was strategic and told the court reporter not to come back because my food is up there. So I have to get her and I will get a banana. And I'll have to do.
All right, thank you.
Yeah, I don't know if that'll count. I'm going to remember that. It's 130, 40.
But it's the same.
Who's counsel on the other side where you're going?
I don't know. It's like, I don't even think I know. I think it's county.
We weren't sure. We just, Ms. Niles included some county attorneys when she was sending the email around. Future reference, that's a spot on pleading that you've got in front of Judge Farmer that got filed long ago, and no one followed 6.1 and sent us a copy. Ms. Niles was pretty stressed out when, I think the last name is Dillingham, someone from your office. Dilligard. Ms. Dilligard starts emailing saying, when are you gonna hear this? And Monica said, she scoured her email like, Judge, they never let us know. And so the reason why nothing happened until now is that we don't look in the docket to see what's an emergency and what's not.
I was under the impression my colleagues had called in and, so
I would fuss at that colleague, Zim or whomever, because whoever needs it. But I just wanted to defend my poor division. It was appropriately assigned to me, and I've already read it. I'm ready to argue about it. I can't today. And so I had to spring it on Farmer. And he said, why aren't you managing this? It was filed long ago. Because until yesterday, whenever Ms. Dilligard reached out, that's the first we heard of it. 6.1, send it in.
I will be, because I'm gonna get pressure from lots of other people to make sure that happens.
You should, but until someone calls or emails Ms. Niles, it functionally doesn't exist.
Well, that's what I specifically asked them to do. So
Yeah,
that's why
okay, I'm sure you did. You know the routine because you've gotten stuff on our agenda quickly. Yes. And so the reason why that one is moving at a different pace is that someone on your team dropped the email or call the staff attorney.
I'm going to find out. We'll make them pay, but at least you gave Judge Farmer something interesting to do today.
Yeah, he was so excited.
I bet. Thank you, Judge.
You bet. All right, I'll be back with they're ready?
A
little bit.
Oh.
Make my life a lot easier.
I'm thinking about starting a 12-step program for email ads.
Like, I don't know what I have an out of office response on.
Me too. They
And
ain't
I'm just
stopping.
like, what are we doing here?
Yeah, there's the same person like emails me. I haven't heard a response yet.
Correct, because I haven't responded. That's why.
You didn't read the auto response? Does that not count? Yeah, I guess it's probably worse for you since you're in supervisory role.
No, I'm just a jack of all trades and everyone knows what to do everything.
That's what I mean, that there's nobody else in my office where all my emails are external, where you got external and.
T-Mobile's gonna be easier, so we're gonna T-Mobile first.
And by the way, that's an old version of the Hansen for the Uber. And it's 5-minute increments.
it's incredibly costly to try to deal with.
No, it jumps 5 minutes.
Yeah.
So you can't jump it's automatically go 5 minutes, 5 minutes, 5 minutes, 5 minutes, so you are correct. I haven't seen that in a while, because that's an old version.
Yeah.
You are correct, you can't just fast forward and jump 5 minutes.
Just like how. Just told you that I can't get for it. So I already left, I'm just accepting. Just know that I'm not gonna have to sit here for 20 minutes.
I said, you're right.
I don't know it.
When I saw the program, I was like, oh yeah, I remember having to deal with that nonsense.
Older,
You can't re-listen to song. You can't re-listen to it, so you're like, no. A lot of times I have trouble understanding what the people on the audience are saying. I'm not second, I think you're doing a great job managing the side of the case, I really do.
Oh, thanks. I just like to be efficient, Ken.
It's like herding cats.
It is.
It's like herding cats. And the expectations that are placed on both of us by a certain person. The person who fills a role for trial, it's like, how long has it been since you did this? Is what I want to say. When was the last time you did this? So, I think you did a great job.
Ronald Vargas decided to file an expert on today for trial that begins on Monday. Because he has all this things he doesn't have to remember a copy of the report to me, like for like a written version of his opinion. I mean,
I had to defend him on contempt charges all the time. So, I don't know how to say it. Seems to think that he's entitled to get his way on everything. I think that judges, you know, local,
he's not ashamed. Yeah, he's not, this is not controllable. Because we had like a whole scheduling order and I felt bad about scheduling order because I found out there was a body cam that existed, but it didn't exist. I had someone else double check for me.
This is a deputy director. Yeah, he said he would take this. I had trouble. Got fired. I still remember the final file for contempt motion against Kate Reese. Because she wanted a multi attorneys.
I remember that.
It's like 600. When I took over the appellate division, we had 180 defendants. With no voice.
You know, I had to, file a motion to have an attorney when I'm supposed to be live.
Yeah, they tried to get that back to me. She hated me.
She didn't like her other lawyer either.
With the one that she left the video with.
No, I know. She didn't like the lawyer that represented her for the plea ultimately, that ultimately just represented her. She got like a possibility of parole on the plea on the day of trial.
I told her at arraignment, we didn't take a while.
And had she taken, and she pled at arraignment for the following year and a half, I probably would have not, I would have recommended, like, Judge Richardson would have taken her life.
Would have right to withdraw.
Right.
Go out
Like
there.
Judge Richardson was like, because after a year, and another year, during the playing of her statement, she acted out. And then there are some calls where she's like, can I consider her prison for this? And I'm just like,
Very entitled.
oh, yeah. Oh, yeah.
The best part of that presentation was the guy who started shouting.
Cameron, the stepdad.
Thinks I have Tourette's.
He does have Tourette's, actually.
I believe it.
Yeah,
that was classic.
And then I ended up finding, because you weren't on the Jeffrey Myers side of it. So Jeffrey Myers got her, I ended up finding calls where he tells her that he researched the law as to what she did, and she can only be charged with cruelty to children in the first grade. And I'm like, which means that you knew.
She's so special, so.
She's a special.
So I got off the case. And then I went to the GPDC, and when I left GPDC, I got on the CBA. The first case they tried to avoid was through the CBD program, this first blood.
We went to Brian Hobbs. Yeah, but Brian did what he could do. Brian got in at the last minute. I mean, he didn't put up with the presentation, but she really done it. And this was after she's seen the video. We had a full call of the video the year before that, and all the evidence in the case.
So I try to explain to my client, is that your behavior after whatever is yeah, and it's not just pre-arrest. That if you get a post indictment that you just accept it. I did. I told her right away that it's brought their legally ask for life. If she doesn't really like it, I don't like it. And it was going to take 5% off the table without a copy of an amnesty. Of all the people who ever again, like her, and she might be and she was poor.
The injuries are really bad. We were able to light up the background of the surveillance video too. So you see them all the way here. The injuries were really bad. I'm so glad I got like 3 of these things.
Is the audio? It works better on the speaker, because on the TV it's so low.
So Judge, how did you get stuck with all the election stuff?
Bad luck.
And luck. So I heard the rumor that another took time served.
I don't know what he got. I just know he played.
Time served. I got lots of clients who will gladly take time served.
Yeah.
I still remember when I saw that Judge Ingram had it for about 10 seconds. She might be the smartest judge in the building. She found a way to get it transferred to poor Judge Whitaker.
That's right. Just clear up this one thing and we'll get started.
But always working there was an election dispute. There was not the election. Which will be lost in litigation.
All right, Ms. Rivers, are you ready? Great. Ms. McCauley, I guess this is currently your witness, Mr. Jordan. Anything we need to talk about before we bring the jurors in?
No, Your Honor.
They're ready to go. Mr. Shepherd, anything from the defense?
No, Your Honor.
Okay. How much is left on the video?
Your Honor, I believe that there's about 20 minutes left, but there is a long period where it's just Condé is sitting by himself, so we would ask that we could fast forward through that section.
You're welcome to. I just wasn't sure that was something that would work technically.
We believe that we have the time stamp close enough to where we can be able to move past action without losing any relevant information.
We'll try. Okay, great. Do you want to try to get it queued up now?
I'm sorry, Your Honor, what was the question?
Mr. Shepherd said he doesn't mind if you want to jump to where we would be before the jurors come in, if you want to test it.
And that way the jurors don't have to watch us.
I do have one more question for you, if you want to go really quick break, okay?
Yeah, there is one more question.
Okay, so that we didn't hear. We were going to take the break, but then she remembered one more question. Okay, let's save that.
I think this is right where we break at 10:58:01.
I thought we already saw that.
Press play.
11:06 is coming and then go to the pause.
Just play what's next, 'cause I thought we saw that.
So we go through the portion. And then. No, too late, okay, you're right. So I'll go to the portion after.
Back.
I know, you gotta.
Oh, that's.
Toggle it. I can get it to 11:06:24, and it's as close as I can without skipping to the next portion. But she comes back in the room at 11:07. Okay.
I think we're teed up. Great. Jurors, please.
All right, adjourn. Here's the president of the county court.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back from lunch. We were in the midst of Ms. Patrick's testimony, and more particularly, playing the recording of her interview with Quindarius Duffy when we had to break for lunch. I asked Mr. Jordan to move the recording forward throughout the break. You may recall, I need to be clear about what break we're talking about. Ms. Patrick, in her interview with Quindarius, had said, I'm going to be right back. I'm going to step away. She ends up being out of the room for 5 minutes, however long it is. But rather than all of us watching Quindarius sit at the table, Mr. Jordan has moved the recording up to the point just before Ms. Patrick returns. So if he's not in exactly the position you remember him in, it's just because we fast forwarded through that. Okay? When you're ready, Mr. Jordan.
Thank you.
I think it was 61, didn't I? I don't think you started to drop something. How did you drop? You know what you did? That's okay. I only have a few other questions. But if you wanted to keep drawing while we're in there, you can, okay? As long as you could still talk with me, okay? So you told me a lot of stuff, okay? And I just want to make sure I got everything right. When you said your mom was at work, your cousin Kate was watching the Mackenzie, yeah. And then your auntie Tina, she had called the doctor. Okay. I know you had told me earlier that Mike stays there sometimes too. Was Mike there that day? Oh no. Okay. What was you there the day before? Yeah. What was you doing there the day before? He wasn't doing nothing. He wasn't doing nothing. Okay. What does Mike usually do when you're over there? Watch TV. Watch TV. Okay. Did you see him that morning? He was very nice. Yeah. Okay, that's fine. Did you see him at all that day? Okay. So I know you said when they called the doctor, the ambulance came in, and you said went to the hospital. Who was all in the hospital with you? My auntie, my grandma, and my cousin, and my rest of my family.
The rest of your family. Who's the rest of your family?
It was my godmother and my cousin and my auntie and my grandma and my uncle.
Okay. All right. Where was your mom?
She was there.
She was there. Okay. Was your dad there?
Yes.
What's your dad's name?
Dude.
You said dude. Okay, so your dad. Do you live with your dad, dude?
No.
No. Where does he stay?
I don't know, because he comes over our house.
He comes over your house? Okay, so got your dad, dude. Does your dad go by any other name? Does your dad go by any other name? Okay. Your dad, dude, is he also Mackenzie's dad?
Yes.
Okay. And you said you see him sometimes at your apartment. How often does he come over there?
He come over all Friday.
On Fridays? Does he come every Friday? Just on Fridays or something else?
On Friday.
On Friday. Okay. All right. Okay. You have any other dads?
No.
Okay. Okay. And you said he was at the hospital with you guys. Great. Okay. Are there ever any other people who sometimes come to your apartment with your mom? Do you have any other friends that will come over?
No.
No. Okay, that's fine. Thank you for helping me understand that, okay? And there sometimes I talk to kids about safety. Are there ever any times where you don't feel safe? If there are any times where you don't feel safe, is there anyone you can tell?
Yes.
Who can you tell?
Mama.
Your mom. I'm sure you live with your grandma now. Are you able to tell your grandma? Okay. Sometimes I talk to kids too about what happens when they get in trouble. What usually happens if you get in trouble?
Mama will tell me it's going wrong.
Mm-hmm.
And she'll say, you watching the TV or you're not playing on TV.
Okay. All right. Tell me how you felt when your kids passed.
Sad.
You're sad. How come you're sad? If you don't want to talk about it, it's okay, Mundy, it's okay. What are you going to do when you leave here today?
Go home and watch TV with my grandma.
Your grandma, do you guys have a favorite thing you guys like to watch on TV? What do you want to do when you go back home?
Play in the backfield.
Play in the backfield? What do you usually play in the backfield?
We used to play hide and go seek.
Hide and go seek. Okay. That sounds fun, okay? I want to thank you for talking with me for areas, okay?
Okay.
Now I asked a lot of questions. How are you feeling right now?
Good.
Good. How come you feel good right now?
Hi, your office, good. That child are talking. Would you want to talk to someone about how you're feeling? Okay, I mean, talk with Big Grandma a little bit about that, okay? Okay. Do you have any questions for me about what we talked about? No, that's fine. It's okay if I keep what you true. It's okay if I keep what you true. Thank you. If you don't have any questions for me, I'll back up to your grandma if you're ready. You ready? Okay. Okay. Thank you for talking to me.
Now, Ms. Patrick, did Quindarius make a disclosure of any kind to you in his forensic interview?
Yes, he disclosed that he witnessed his sister as she was passed away.
Now, were you able to determine the relationship between Quindarius and Michael Reynolds?
At least from what he said in the interview, it sounds like he just knew him as his mom's friend.
Okay. Now, were you able to determine how old Quindarius was when this forensic interview was conducted?
I think he was 8.
Okay. Now, in your experience as a forensic interviewer, would you expect an 8-year-old to be able to recall all the details of an instance of violence or death that he observed?
No.
Okay. If Quindarius were older, would you expect him to remember more details?
Probably a little bit more, but depending on the incident, sometimes trauma can make it hard for people to talk about things regardless of age.
Did you see any evidence or signs of coaching in Quindarius's forensic interview?
No.
Did you see any signs of suggestibility in his forensic interview?
Probably just due to his age, but nothing explicit in his interview that made me feel like he was very suggestible.
If I may have one brief second.
Mm-hmm.
State's now going to publish the State's Exhibit 11. Now, Ms. Patrick, going back to the forensic interview synopsis that's in front of you on the screen in the form of State's Exhibit 11, what is the purpose of a forensic interview synopsis?
Usually so we can just have on the record a brief account of what the child said in the interview and any recommendations.
Okay. And do you normally do a write-up of a summary of what you learned during the forensic interview?
Generally, yes, just basically what the child stated in the interview, but usually summed up.
And do you recall, and we may need to scroll down, what your overall summary was of this forensic interview?
Yes, so I have the few sentences listed in the summary, just noting briefly what he said, and just including those details about him, Mackenzie passing and him saying what he saw.
No further questions at this time, Your Honor.
All right. Mr. Shepherd.
If I could look at that exhibit for a minute. You just put it back up on the screen, so I was almost finished reading it.
Do you want the physical one?
Sure.
Yeah.
Give it that. I was almost finished reading it.
State's 11?
It's 11.
I think it's right there.
Yes.
I think I see an 11.
Oh, okay. My apologies. Didn't see that.
One second. I have no questions.
All right. Jurors, any questions for Ms. Patrick? All right. Thank you, ma'am, for your time. Sorry we had to keep you over lunch. Hopefully you got a good meal.
Thank
you. Next witness.
State called Ricardo Leal.
You swear or affirm that testimony you will give the truth, the whole truth, and the true self of God?
Yes, I will.
Go ahead, have a seat.
Thank you.
Can you say, spell your name for the record?
Yes, sir. My name is Ricardo Leal. It's last name spelled Leal.
Good afternoon, Mr. Leal. How are you currently employed?
Good afternoon, ma'am. I work for T-Mobile Corporation.
What do you do for the T-Mobile Corporation?
I serve as a records custodian when subpoenaed to testify on phone records.
And prior to working for T-Mobile, have you worked anywhere else?
I did work for Sprint Corporation, which was another mobile carrier. So I started with Sprint Corporation back in 2002. T-Mobile and Sprint merged together in 2020, April of 2020. So at that time, I essentially learned the information of T-Mobile, like how their records are kept, and assumed the same responsibilities as I had with Sprint Corporation in the same type of role.
So just to clarify, when you worked for Sprint Corporation, you were also certifying records and making sure that they accurately reflected the business activity of Sprint?
Correct.
And you operate in that same capacity in T-Mobile currently?
That's correct.
All right. Were you asked to review records for this particular case?
Yes.
And were those T-Mobile records, Sprint records, or both?
Both. So there was a set of Sprint records and another set of T-Mobile records.
I'm going to start with the Sprint records. I'm going to show you what's marked as State's Exhibit 14. You take a look at those and let me know if you recognize them.
Yes, these are records that I reviewed prior to coming in today.
And are those records relating to a specific phone number or account registered with Sprint?
Yes,
And was that account registered in 2017?
it was, it actually goes back a little bit further to 2015, but yes, the information that was asked for was in the 2017 time range.
And the information that's contained in those records, is that information that was routinely collected by the Sprint Corporation in 2017?
Yes,
Do those records appear to be a true and accurate reflection of the records for that account in 2017?
yes, ma'am.
All right, this time around, the state would offer State's Exhibit 14 into evidence.
No objection.
14 is admitted.
Thank you. So can you see the screen in front of you?
Yes, ma'am.
Perfect. So I'm just going to scroll through this front cover page. But tell us a little bit about the information that we see here on this second page.
So this is the actual subscriber information, and it highlights the information for the specific telephone number that was queried along with the date range for the request. And that's on the top few lines there. Basically, with every case that's created, they would turn it into an actual case number and assign it a case number so you could find it or be able to locate it. Typically, you could do that with the telephone number too, but a case number is assigned. And then it would show the account details for the information that was requested for that time frame.
Okay. So for this particular account, it's registered, the account billing address is registered to the name here, is that correct?
That's correct. So the account billing address goes back to Sarisa Benson, and that's the last known address, that first one at 974 Manigault Street, Southeast Atlanta, Georgia, 30316.
Now, just in general, with cell phone accounts when they're created, is it sometimes where someone creates an account in one person's name, but another person is really utilizing that phone number?
That happens.
So moving through the records and kind of what we're looking at here. I want to move through. What are we looking here at the call records?
So these are the actual call records. And they give you the information for the calling number. That's the number that's doing the calling. Basically, it's network information. And so it wouldn't be like what you're actually seeing when you receive your phone bill. It's what's being transpired from the network into billable calls. That's what you would see on your, like, a phone bill. And so basically this is breaking it down. It shows the calling number, the call number, the dial digits. It also would highlight what type of transactions taking place, whether it's inbound or outbound. If it's going to voicemail, there's it would be an indication on that as well. And then it shows the start date and start time. And then it evolves into other things that all relate back to the network.
Is that what we see over here?
Correct. So it has the duration would be the total time in seconds. And then it's going to differentiate between voice or text. And then it will also show the network element ID, which has to do with the tower information. And then it gives a first cell and last cell. That's the actual information that you would have to do a lookup on to find the tower location. So basically those numbers, they all mean something. The last 4 digits would be the tower location or the cell ID number. The first number would be the sector or the side of the tower that the radio frequency from the telephone call bounced off of.
And Mr. Leal, I know that you're not an engineer, but can you just briefly explain why there would be, what tower data is and why it's in cell phone records?
So basically, they keep all this information because it's network information. They use it for network optimization as well as billing purposes. Like, that's why we keep the information. And they want to know which tower the call went through. That's basically it.
Thank you.
Sure.
So I just kind of want to use one of these calls as an example here, and I want to focus kind of on this call that's right here, this outbound call at 9:49.
Okay.
So what was the calling number?
It's 678-612-6814.
Okay, so that's the number, actually, I think that's this account number.
Correct.
So this was an outbound call made by this account.
Correct.
And what was the dial digits?
911.
And at what time was that call made?
That was at 9:49, 30 seconds in the morning of June 8th, 2017.
Does that mean that if I dialed 678-211-0984, I'd also get 911?
To the best of my knowledge, yes. It's the way that the system picks it up. So
It
the
needs
network,
the 10 digits or whatever the math is. I hit 911 on my phone, but that's actually the phone number for 911.
correct. That's how it routes through to 911.
Okay.
So because it's a network, it's operating through that network. And so it actually dialed 911, but it shows that it picks up on the number that actually patched it through. Does that make sense?
Yep. Sorry, Ms. McCall.
That's all right. Mr. Leal, so trying to pick up on the judge's question. This is kind of like a new age switchboard, essentially. When dialed out to a different number, but really the dial digits are 911.
Correct. It's an assisting number.
It's an assisting number.
So it's called a temporary local dialing number. It's pertinent to the switch that the tower is connected to.
So this outbound 911 call at 9:49, let me just scroll to the other side of the screen. What kind of call was that call?
Voice
And approximately what time did it end?
at 9:55 and 47 seconds.
And that's reflected here with the length as well, the duration in seconds?
Correct.
Okay, all right, thank you.
You're welcome.
And for the purposes of Sprint records, what time zone are these records in?
It's wherever the phone's operating, so it's switch time, operating in Atlanta.
So if I'm in Atlanta, it's gonna show Eastern Standard Time,
Correct,
but if I was in Colorado, it would show Mountain Time.
correct.
Thank you.
You're welcome.
So let's move to the second set of records that you looked at. Are you asked to look at a set of records from T-Mobile as well?
Yes.
Show you what's been marked as judgment as council states exhibit 13.
Thank you.
Yeah, thank you.
Okay.
And what is states exhibit 13?
So T-Mobile records, subscriber information, call detail records, with cell site information and, a key to understanding the information, basically.
And are those records that were maintained by T-Mobile in 2017?
Yes,
Are those records a true and accurate reflection of the information that was collected by T-Mobile regularly in 2017?
yes, ma'am.
They appear to be altered, changed, or related in any way.
No,
This time around, the state would offer states exhibit 13 to evidence.
I could look at it again. Obviously, when you do a cell phone record, you catch a lot of stuff that.
So I don't want you to offer your thoughts about what cell phone records are, but you can certainly look at 13.
We're good.
So no objection to the admission of state 13.
This time, not ever.
Okay. Not during this trial, it's admitted.
All right, thank you, Judge. Okay. So I'm gonna scroll up here, I'll scroll back in. So what are we looking at here?
so this is the subscriber page, for the information that was sent, through legal process for the legal demand, essentially. And it's like the other subscriber information, it just highlights a different person for the number associated with 404-547-0324, which is in the name of Stevie Pate with an address of 187 Kipling Way in Riverdale, Georgia. And it shows the active date for that telephone number. And then it gives the information about the subscriber information, billing details, those types of things.
And then I know these records appear very small on the screen, but tell me what I'm looking at over here in these first few columns on these records.
So it's similar to the other records we looked at as far as the call detail report. It has the date, it has the time. The time is in UTC time or Universal Coordinated Time. So you have to do a conversion for this time or gate range, essentially, you have to do a -4-hour conversion, so it's marked in UTC time. You have to subtract 4 hours to get it to Eastern time. And it has the duration, and that's in seconds as well. And then it differentiates between call types. It shows the directionality, as well as the calling number, the dialed number, the called number, like all that's very similar to what we saw in the other one. And then it also has a destination number, which is typically the same as the called number. It also includes other information like the International Mobile Subscriber Identification Number, and then the equipment ID is the International Mobile Equipment ID, or IMEI. And then it has a completion code. If it was an abnormal completion, it would mean that it wasn't a completed call for whatever reason. If it was completed successfully, or text, if it was completed successfully, it would show that. And then there's a service code that would highlight if it went to voicemail or different scenarios, which is in the information handout that we sent out. Then it goes into the switching information as well as the cell tower information that we see on the screen now.
And this cell tower information is where the call is, what's the closest tower that the phone is connecting to, is that accurate?
Correct, it's the tower that handled the transaction. So basically you would use the latitude and longitude. The address is there to be able to locate the tower, but it's not necessarily always the exact location of that tower. It's in that general area.
So going back to what we see over here, and kind of focusing in here on this time frame around June 8th of 2017. I'm just gonna come behind you again because I have some questions.
Sure.
What does the MOC, what does that mean?
Mobile outgoing call.
So what would that would be that the call is being made by this phone?
Correct, it's going out from the record holder.
Okay. And then what about MTC?
That's mobile terminating call. So that means it's terminating with the record holder. So it's a call going into the telephone number.
So looking at this set of calls right here. So for example, if we're looking at this call right here on 6/08/2017 at 12:41:12. Now, is this in 24-hour time?
It is in 24-hour time, so it's UTC time, but it's in 24-hour time. So to get it to Eastern time, you'd have to subtract 4 hours, which would be 8:42 and 36 seconds in the morning, correct?
So this one here at 12:45 would be 8:45 and 30 seconds. Would that be accurate?
Yes.
And that's a 506 second calls?
506 seconds.
And that was the outgoing call made by this phone number to this phone number, is that correct?
Yes, ma'am.
So this would be 8:45 in the morning, a 506 second call outgoing made from this phone to this phone.
Yes.
And scrolling to the other side and staying on that same call right here, the cursor is, it looks like it was completed successfully.
Correct.
And then the tower information shows 3045 Donnelly Hollow Parkway.
That's the estimated area. You would actually use the latitude and longitude,
Okay.
but it's going to be in that general area.
And then the next few calls that we see are showing the phone kind of going to different locations. 1325, these would be the towers that it would be, I guess, hitting off of 1325 Virginia Avenue, and then it looks like down to Riverdale. Is that accurate?
In that area.
In that area.
Yeah. It's not, it might not be the exact location of where the tower is.
Right.
And so
You could be at 1207 Virginia Avenue and it's showing the tower at 1325 Virginia Avenue?
It could happen.
All right.
The only way to really know is to actually use the latitude and longitude. It might show up as the exact same address number, but it might be slightly off.
All right. Thank you. I'll pass the witness.
Thank you.
Mr. Shepherd, do you have questions for Mr. Leal?
No, I do not.
Okay, jurors? All right, thank you, sir, for being here.
Thank you, Your Honor.
Where's your next stop?
I get to go home, but I'm going to Toledo, Ohio next week.
All right, Atlanta was happy to have you.
Thank you, appreciate it.
Next witness?
State calls for Hansen.
Praise me and raise your right hand. You swear to affirm that the testimony you will give, truth, the whole truth, and nothing but true self God.
Yes.
Truly, and have a seat. Thank you. Can you state his name, please?
Yeah, it's Christopher Hansen, Hansen.
Good afternoon, Mr. Hansen. Just as a forewarning, I know that you speak very quickly. You may have to slow down a little bit for Ms. Rivers. Could you tell us where you're currently employed?
Yes, I work for Uber.
And what is your position with Uber?
I'm public safety manager for the central US.
And what is your professional background that allows you to have that position?
I spent some military, but I spent 15 years in law enforcement. So I worked in mostly counterterrorism, internal affairs, and I was a sergeant and I ran a team that worked with complex vehicle movement data and cell phone records.
What was the adjective before movement data?
Sorry, complex.
In between complex and movement?
Complex vehicle movement data.
Vehicle.
Sorry.
Thank you. I didn't hear it.
It's my accent. So yes, 15 years as a police officer. And then I moved to Uber and I looked after the UK and then Europe. And then I've moved over to the US to look after the central US.
And what are some of your duties and responsibilities?
So senior manager, my role is the interface between law enforcement and Uber. So if there's a complex case, I may help advise law enforcement as to how we can assist them in those high profile cases. We have a data team who provide data, but I'm more of an expert in that interface between law enforcement and us to protect privacy, but also to assist law enforcement in what they compel from us.
And Mr. Hansen, were you asked to review some data as it relates to the state of Georgia versus Michael Reynolds?
Yes.
What data were you asked to review?
I was asked to review if the person in question had been driving on our platform as a driver on a particular date.
And were you able to recover any information about a driver by the name of Michael Reynolds?
Yes.
And what information were you able to recover?
So if I could just split it, I was given the data from the data team, which showed that there was no trips as a driver on that date. And obviously, because I was coming here to look after those records, I conducted my own searches and found that to be correct, that there was no data showing this person drove on that date.
And so let's kind of walk that back. So you were provided some data that said that there were no drives on, or no data on June 8th of 2017. Is that accurate?
Yes, we refer to it as DNL, data not located. So we did not locate any data on that date showing that the person drove on our platform.
Okay. And that was the initial response, is that correct?
Yes.
Okay. And then you conducted your own search?
Yes.
Did you determine that that data was incorrect?
No, that data was correct. I could not find anything showing that person was a driver on that date.
There was some data related to that account, however, that was recovered. Is that accurate?
Sorry, could you be specific in terms of?
Sure. Did you review some records that were produced from Uber related to that individual?
Yes.
Do those kind of republish, Your Honor, what's been previously admitted as State's Exhibit 12 or 22?
22.
Thank you.
Is it in front of you on that screen, Mr. Hansen?
Yes.
Make it a little bit bigger.
Yeah, I can see that.
Is that sufficient?
Yes.
Okay.
Thank you.
So this data, what does this tell us?
So this is GPS records from the data team. This is the standard way they would produce it. It shows GPS of an account.
What does that mean, GPS of an account?
So with our app, as soon as you open the app, you're giving us GPS data. So for example, I just looked at the Uber app while I was sat out there. That will ping GPS to Uber. When the app is open, we are collecting data. That's in our terms and conditions. When you use our service, you say, I want the vehicle now. You don't have to put in where you are. So we are collecting data. So this shows that an app is open.
Does it show or indicate that while the app was open, that the driver was available for fares?
No, you can't say that from that data.
Okay.
So I can just clarify that. I have a driver account because once a year I'm allowed to drive on a platform to learn. I have a rider account, which I use a huge amount. When I open the app, I'm not delineating whether I'm ordering food, delivering food, ordering rides, or driving on the platform. When I open the app starts collecting GPS data. So you have to look at the trips on the driver account and see if the person was actually driving on the platform. What I'm looking at here is standard GPS, but no, it doesn't say anything other than it's collecting data.
So it just says the app is open, essentially.
Absolutely, it just says the app is open, yes.
Thank you. And did you conduct a search as to whether the account for the driver, Michael Reynolds, ever picked up any rides or drove as a driver?
Yes.
Did you locate any of those rides?
Yes, certainly the person looked to have conducted trips. They seem to have conducted a few trips on one day, but not the day in question.
What was the one day that those trips were
The
conducted?
7th.
And do you remember the time frame in which those rides were completed?
Not right away, but they were only within the 7th. There were no trips as a driver on the 8th.
All right. Thank you. I'll pass it.
So you stated the trips were on the 7th of June?
Yes.
Okay. And about how many trips on June 7th?
Without it in front of me, I think 4.
Okay, thank you. Nothing further.
Follow up? Jurors? Thank you, sir, for being here. You're done.
Thank you.
That was it.
Thank you.
You should leave before we change our mind. I hope so.
I hope he is as well. Remember the state called investigator Ronald Sluss.
Raise your right hand. Swear or affirm that testimony you will give will be the truth, the whole truth, nothing but the truth, so help you God.
So help me God. Thank you. Ronald Sluss, RONALD,
Good afternoon, Investigator Sluss. How are you currently employed?
with the Atlanta Police.
And what is your current role with the Atlanta Police Department?
I am a detective.
And are you assigned to a particular unit or division within the Atlanta Police Department as a
Yes.
detective?
Yes, ma'am. I'm currently assigned to the Homeland Security Unit.
And what are some of your responsibilities in the Homeland Security?
Cyber crimes, extortion, public corruption, domestic terrorism.
Prior to being in Homeland Security, what unit were you assigned to?
To the homicide unit.
And what did you do in the homicide unit?
We did murder investigations, kidnappings, active kidnappings, whatever special investigation the chief deemed that we needed to do.
And in the course of your time or prior to being in homicide, where were you assigned?
The special victims unit is a detective.
And through the course of your tenure as a detective, have you developed a specific expertise or subject matter that you testify in frequently?
Yes, ma'am.
And what is that?
So I'll do subject matter expert testimony on call detail records, your cell phone records, as well as GPS and device locations.
And what, do you have specialized training in that area?
Yes, ma'am.
Could you detail that training for the jury, please?
So initially it was through the FBI. They have a CAS team. They have a team that basically has perfected cell phone analysis. I've worked with the Secret Service, through the DEA, through a bunch of different federal agencies doing the exact same thing.
And so what type of things do you learn about in that training?
So like specifically in this case, you have call detail records. So everybody, well, pretty much everybody has a cell phone. And your cell phone company basically holds records that we can use to analyze, to figure out where about the device is when it's making a phone call or making a text message, using data. There's all kinds of different things we can look at. So we can look at tower locations when your phone is operating with on the network and what particular direction from that tower that cell phone is being used.
And have you previously testified in this area?
Yes, ma'am.
And were those for your own cases or other detectives' cases?
Both for my own cases and for other detectives' cases.
Have you testified for other agencies as well?
Yes, ma'am. I've been qualified as an expert in Fulton County Superior Court, Cobb County Superior Court, and DeKalb County Superior Court.
At this time, Your Honor, the state tender Detective Sluss is an expert in cell phone global positioning expertise and call detail record analysis.
Mr. Shepard, do you have a need to examine Detective Sluss on his credentials at this time?
No, Your Honor.
Any objection to having Detective Sluss qualified in those two fields as an expert?
No, Your Honor.
All right, Detective Sluss, for the purposes of this trial, you are qualified as an expert in the two fields that Ms. McCauley just described.
Yes, Your Honor.
Thank you.
Thank you, sir.
Detective Sluss, in advance of testifying here today, did you review any records related to this case?
Yes, ma'am.
What records did you review?
So the T-Mobile records associated with the defendant, as well as some Uber records.
And did you prepare an analysis of those records based on call detail records and global positioning of those devices?
Yes, ma'am, I did.
And did you prepare a report?
Yes, ma'am, I did.
I'm going to show you what the President Martin showed to Defense Counsel States Exhibit 99. You can take a look at it. Let me know if you recognize it.
Yes, ma'am. This is a PowerPoint that I created.
And would the use of that PowerPoint assist you in illustrating your testimony to the jury today?
Yes, ma'am.
At this time, Your Honor, the state seeks to admit States Exhibit 99 into evidence.
I think this is more probably admitted as demonstrative evidence. It's to illustrate and help with testimony. But it does have original commentary within it that is testimonial of nature. So once again, I have no problem with it being admitted and published, but I would argue that there is continuing witness information contained within this demonstrative piece of evidence that should not go out with the jury.
Okay, well, we can take that up when we cover that topic as to all the exhibits. My only question for you, Ms. McCauley, on the exhibit list, I've got 98 as Detective Sluss PowerPoint, 99 Detective Sluss report. You've called this 99. I'm fine if that's 99. I don't want 98 to come behind it and confuse things.
I don't think we'll have to worry about 98 because I think all the information in 98 and 99 are combined into 99.
99 it is. It is admitted. It may be published, and I will defer till later whether it goes further than that in this trial. Thank you.
Thank you. All right. So I'm gonna give you this PowerPoint tool. And if you just walk me through the first few pages of your report.
Sure, of course. And if I speak too fast, please slow me down. I have a tendency to get a little excited. All right. So the beginning, I apologize. So the beginning of this PowerPoint is just me, who I am, the Atlanta Police Department. The second is just kind of give you an idea about what it's about, the murder of the victim, Mackenzie Duffy, at 208 Harwell Place Northwest on June 8th, 2017. Detective Darren Smith was the lead detective, and I was the one who did the analysis. So Detective Smith, again, being the lead detective, obtained historical call detail records for the defendant's phone. Fulton County District Attorney's Office obtained GPS information as well that came from Uber. So we're looking at two different things. We're looking at the CDRs that the T-Mobile captures plus the GPS information that Uber captures. So what are call detail records? I kind of gave you a little bit of a hint earlier, but your carrier basically holds certain records, okay? They're there to capture the tolls. So they know your incoming and outgoing phone calls, your incoming and outgoing text message, the data that you use, and there's other things that they capture as well. And what we're able to do with that information is basically use it as a demonstrative. So we're able to take just basically raw data, and then we can kind of plot it out. So how does a cellular phone work on your network? So the phone that you have in your pocket right now, or the phone that you have back there in your bag, is basically just a little handheld radio. All right. Well, number one, it's a very expensive little pocket computer. So we'll start there. All right. From there, it becomes a really nice camera. From there, it becomes what it does worse is probably actually making phone calls. They've become very, very sophisticated over the years, but what they do when they're making phone calls is they're using RF signals, radio frequency signals, to go from your device to the tower, and then from the tower into the network. So if we were to kind of plot this out, so if you kind of want to know how your stuff is routed, so it's going to go from your device to a tower, okay? From the tower, it's going to go to a group of towers. From the group of towers, it's going to go to a main switch. That's kind of the brains behind the operation. So when you dial in your mom's phone number, you hit send, it's going to go from your device to the tower, to the group, to the network, okay? And then from the network, it's going to retrace its steps back to the cell phone that you're calling or the landline that you might be calling, okay? So we can go from the device to the tower, to the group, to the network, and then it retraces its steps. So how it does this is it uses RF frequencies to digitize information, and it's going to go from your device to a tower. Now, I don't know if you guys drive down the road and ever see towers on your way to work. Usually you'll see them very easily on the interstate. Once you get into the inner city stuff, they'll be plastered on the side of buildings, all kinds of different ways to be able to use this. And because of the way that the network works, especially here in Georgia, is that you have sectors of responsibility. So you're going to have a site. So here in the illustration, you're going to have a tower, right? And then it's going to have typically 3 antennas. That's pretty much given a sector of 120 degrees. So 120 degrees times 3 gives you 360. You have now 360-degree coverage around that area that the tower is responsible for. So what we can do with that particular information, if we know exactly where the tower's at, and we know that direction that each antenna is pointing, we can see what direction the device is using that tower from. So now we have a specific location in the area that the device is being used, and now we have a direction from the tower that that device is being used.
Detective Sluss, before you move on, can I ask you a question about that?
Sure.
So if your phone is connecting to one of the 3 sectors,
Mhm.
say it's the sector that's facing south.
Yes.
So, just for example here, so I'm using a cell phone and it's connecting to this.
Yes, ma'am.
Would that put my phone in the direction of being south of the tower or on this side as opposed to being on one of these other sides?
Yes, hypothetically. So what you're going to do is, so let's pretend that I'm a tower, right? And somebody in the back of the courtroom wants to make a phone call, all right? And your device says, you know what, I need to make a phone call. Here, please let me make a phone call. I'm going to sit here in the sector that's oriented in the direction of the device, is going to capture that signal. Now, the sector behind me isn't going to capture that signal. It's pointing in a completely different direction. So that gives us a general idea of where the device is based on the connection.
So that's how you're able to tell, I guess, where the phone is. It's not just bouncing off the tower, but it's giving a direction off of that tower.
A general direction, yes, ma'am.
Thank you.
Mm-hmm. So when we have this information that are in these cell phone records, now we have a general idea. We can plot this out on a map. So if we know where the tower is located and we know the direction the sector is responsible for, we can plot this out on a map and we can get a general idea of where the device happens to be operating when it's operating. So to kind of give you a little bit of a demonstrative. So this right here is an outgoing phone call made from 404-547-0324, and it's calling 404-781-8135. Now, in these records that this company holds, you'll see some other things. So you'll see a location that is your latitude and longitude. That's exactly where the tower is located. So now we know where the tower is located when that phone call is being made. And then we have the azimuth. Now, azimuth is the direction from the tower that's the middle of the sector. So we know that the sector is about 120 degrees, and we know that azimuth is 160 degrees. So if I were to be the tower 160 degrees away from me, plus or minus 60 degrees, that gives me my 120 degrees of responsibility for me to be able to take and receive phone calls, text messages, and data. Okay? Once we know that, then we can sit here and plot this out. May I stand up, Your Honor?
You may.
So imagine this right here being the tower itself. So the apex of this little pie. Okay. And what we want to be able to know is the antenna is responsible for this 120 degrees of sector. So we would know that when this phone call is placed, an outgoing phone call, this device is somewhere in the area of this pie because that's the antenna that it's using. So it's not using this other antenna, it would be in a different location. It's not using the other third antenna, it's in a different location. So we can get a general idea of where the device is just based off of this one phone call. So we also have to go over some GPS stuff. So global positioning system, greatest thing that's ever been created by the United States, I think. So GPS was originally Navstar. That was basically run by the U.S. military and the U.S. government, and now it's governed by the U.S. Space Force. It provides a geolocation for time and information to where the device is compared to where all the little satellites are. Now, the U.S. now controls, I think, either 33 or 34 satellites that are orbiting the United States or orbiting the Earth. And they were able to basically trilateralization of the device. So it uses time and distance to calculate a fixed point. So if you have 3 or more satellites that can communicate with the device, it will measure the time and distance that it is from that. It can give you a GPS location. Anything more than 4 can actually give you not only a GPS location, but it can also give you the actual, the elevation of it. I mean, it can literally put you within it. So how accurate is GPS? So the US government says the GPS is accurate to about 6 meters or about 19 feet. And that's to be considered in perfect condition. So 19 feet is somewhere right around more than, or a little bit less than your jury box. So you guys have an understanding about how accurate it is. And they've had multiple real world tests that have been conducted to determine accuracy. And even in challenging conditions, in bad weather, in different microclimates, it's going to be accurate to at least within 16 meters or 52 feet. So to kind of give you an idea, when you're looking at a GPS coordinate, you know that it's at a minimum within about 52 feet. So one of the sets of records is the Uber records. The GPS data provided is the best available raw data location provided by the driver's device operating system from the time the device or the driver dispatched to trip completion. So basically Uber is saying when you open up our app, we're going to start collecting GPS data from your device. So wherever your cell phone is, when you open up our app, we're going to start collecting data. And that data is the stuff that we're going to be looking at here. So there's going to be 2 different basically times that that app is open. That's times of interest. And then they were able to also give us driver information. So we know the legal name is Michael Reynolds. It gives us the 547-0324 is his phone number, email address, date that he's had Uber as an account, the vehicle that he was using at the time. And we can take that information and then we can plot this out on top of the cell phone record information from T-Mobile. So in this presentation, am I going too fast?
No, you're fine.
Okay, thank you, ma'am. So in this presentation, we're going to do two sets of data. So we're going to worry about the T-Mobile records, and we're going to worry about the GPS information that we're going to get from Uber, and we're going to kind of combine the two during a time of interest for this particular case.
So what did you identify as the time of interest for this particular case?
So the 911 call came in at 9:49 a.m. Okay. And we know that the crime scene location was 208 Hartwell Place based on having to go there to work the crime scene. And then the incident date is June 8th, 2017.
Right.
So here's subscriber information. So I'm going to dig into this a little bit. So your subscriber information is the subscriber information that T-Mobile collects on the payee of the account. Okay. And when I say payee, this is the person that pays the bill. So to give you an example, I have a personal T-Mobile account. All right. And then my wife and my kids are underneath my T-Mobile account. If you were to look at my son's cell phone records, it would be wherever he is, but it would say my name because I'm the guy who ultimately has to pay the bill. So that's kind of what we're looking at here. It'll give you the subscriber name, which is the payee, the address where the bill goes. It's going to give you IMSI, International Mobile Subscriber Identifier. So that's your account number, basically, that goes with your cell phone. Then MSISDN, I can't remember the acronym for that one, but it's basically your cell phone number. You continue to go down IMEI, that's the International Mobile Equipment Identifier. That's basically the social security number for your cell phone. So you know how you can port your cell phone number from cell phone to cell phone? Well, the IMEI stays with the cell phone forever. It never goes away. Even when you chuck it in the trash, it still will keep that IMEI. It stays with the social security number of it. So Detective Smith identified the phone number associated with the defendant as 404-547-0324. It runs off the T-Mobile network, and our T-Mobile network records come in UTC. So let me go over UTC a little bit. That's Universal Coordinated Time.
Before you get to that, just is the number that you identified as being on the T-Mobile records the same phone number that was referenced in the Uber records?
Yes, ma'am. It's the same one.
Can you explain what UTC is?
So UTC is how we capture time. Anybody, if you were in the military, everybody knows Zulu time, all right? That's England time. We're using the exact same thing. So you've got UTC, Universal Coordinated Time, which is basically Zulu time. It's also Greenwich Mean Time, all right? We can call it three different things. But instead of having it in local time, like Atlanta time, it's going to have one registered place that it captures. And then we can sit there and deduct whether we're in standard time or whether in daylight savings time. We can either subtract either -4 or -5 hours to get our local time here in Atlanta. So so go back up on here. So the payee is Stevie Pay, okay? That's what T-Mobile registers as the payee of it. Now, when we actually look up that device on database records like LexisNexis, we're looking at, okay, who's the person actually that we believe is using the account. Comes back to Michael Reynolds in Riverdale, Georgia, gives the same phone number, the 404-547-0324. And then we're going to go on to the first phone call.
So in analyzing the records, Detective Sluss, did you look at, did you determine when that first phone call was?
So on June 8th, there was a time when that phone was not in use. Okay, so I can't track it before, but from 8:40 a.m. is when that device becomes active. It makes a outgoing call to 404-781-8135. It's 43 seconds long, and it's using a tower that would service 208 Hartwell Place.
What is the next call that you identified?
So now we're gonna kind of go through some of the Uber stuff. So the very first phone call that we get of the day is the 8:41 phone call. Now that Uber app is going to be open on this device. Now Uber's starting to collect GPS data. So that's what this right here. So Uber collects it just the same way it collects it in UTC time. And all we have to do is convert it back to our local time here in Atlanta. So they collected 22 GPS data points between 8:43 a.m. and 8:44 a.m. in Eastern time. Now, if you look up there, it says 12:43. All right. So what we're doing is we're backing it up to put it into Atlanta time. So during 8:43 and 8:44 p.m., this device is just north of 208 Harwell Place near the Petro Center. I don't know if you're familiar with Atlanta, but there is a gas station there called the Petro Center that does both cars and large trucks.
And Detective Sluss, just to clarify, is that where this device is for that 8:43 to 8:44 a.m. hour or time period?
Yes, ma'am, it is. So the next call that's made from this phone, now again, we're going back to T-Mobile records, is going to be at 8:54 a.m. All right. The device is now moved to the Ben Hill area of Atlanta. That's Southwest Atlanta. It runs off of like 166 and 285, if you're familiar with that, the Greenbrier Mall area. So we have an outgoing phone call that was 20 seconds long. That's the 404-781-8135, the same phone number that you saw a little bit earlier ago.
And Detective Sluss, did you identify that there was any Uber data that corresponded to this time period?
No. So the stuff that we had before was, all right, the first time this phone wakes up and is now on the network that day is at 8:41. That's the outgoing phone call here over near Harwell Place. And then we have the Uber app that opens up and then it starts collecting data points, 22 of them. All right, between 8:43 and 8:44, and then that app's closed, so it stops collecting GPS data. The next phone call that we have is at 8:54 a.m. and the device is over by Greenbrier Mall. So from there, the device makes 3 phone calls from the same cell site. All right, so we're at 9:06 a.m., 9:09 a.m., and 9:27 a.m. And it's in the area of Egan Park and East Point. So that's just south of the city. So all those 3 phone calls use that exact same tower, use that exact same antenna that is northwest of where that tower is.
And Detective Sluss, I was just looking at this map. Is this near where the airport is?
It's close, yes, ma'am.
And do we see Virginia Avenue along here?
Yes, ma'am, you do.
And you're familiar with the city of Atlanta being a law enforcement officer. Are you familiar with the McDonald's located in this area?
Yes, ma'am.
We're on 1207 Virginia Avenue?
Yes, ma'am.
All right. What's the next series of calls that are made?
So then he opens up his Uber app again. So now we're going to collect another set of data points. So on his phone, he opens up the app, and now we've got another 35 GPS data points between 9:50 and 9:55 a.m. All right, everything's in UTC, so we're going to convert this back to Atlanta time. But going from north to south, each one of those dots is a travel point from 9:50 to 9:50 a.m. So you'll see it going southbound on 85, and then it's going to get on to 285 east before the app shuts down and the GPS locations stop getting collected by Uber. And then we're going to have this big gap of kind of what's going on. So between 10:08 and 10:30 a.m., the device makes 31 calls, okay? And then the device is going to be in College Park, and it's going to be south of the airport making phone calls. So each one of these little sectors is where this device is connecting at any particular time, okay? It's not near the crime scene. It's just south of the city, south of the airport. At 10:46, the device returns to the area of Harwell Place. It's not the same sector that it was using earlier, but it's a cell phone tower that's close by. It's an outgoing phone call to 404-275-1952. From there, at 10:47 a.m., the device is utilizing a tower that serves Harwell Place. It's an outgoing phone call that lasts 132 seconds. That's a little over 2 minutes. The 404-849-8505. And then by 8:50, the device has now started to move. So remember, in this one, we're over here near Harwell Place. I can't say it's at Harwell Place, but I can say it's in the area of. It's making this phone call. And then the next one at 10:50, now it's moved southeast of the location. From that 10:50 call comes the next call, that's 10:55 a.m. And now it's moved itself over to the area of Mechanicsville. That's just south of downtown where 75, 85, and basically I-20 meet. And then at 11:09, the device is using a tower that will service Children's Health Care of Atlanta. And that's where it stays. So there's 2 phone calls, one at 11:09, and I think the second one is at like 11:13, and then the device basically gets shut off or goes dark from the network. So there's incoming phone calls that are missed, but there's no outgoing phone calls.
All right, thank you, Detective Sluss. So I want to turn just to the records that you reviewed, and I just have some questions.
Yes, ma'am.
And in your presentation that we just saw, we looked at activity on the phone. I think that was around 10 o'clock in the morning, or around 10, 11 o'clock in the morning, or between the 10 and 11 o'clock hour.
Yes, ma'am.
And in reviewing the records, did you determine where the phone was around 10, 11 in the morning?
It was south of the city, yes, ma'am.
Okay. And there were a number of calls that were received at that time?
Yes, ma'am. 31 total between 10:08 and 10:30.
From about 10:08, from your knowledge of the city of Atlanta, from where the phone was around 10:10, 10:08 in the morning, how long would it have taken someone to get from the location of the phone is at to that Children's Healthcare of Atlanta location?
I'm gonna object on speculation.
Yeah, response?
Yes, Your Honor. The detective testified he's been a detective with the city of Atlanta, is very familiar with the city of Atlanta, and very familiar with GPS coordinates as well as global positioning of devices, and certainly can provide his opinion as to how far those 2 locations are from each other, given the fact that both of those locations appear in his presentation.
All right, I think your question was a little different, which was how long would it take? But I think those very same qualifications and his experience with the Atlanta police do qualify him to offer a lay opinion about how long it would take, subject to cross-examination.
But you don't know on the record that you never know how long anything in Atlanta is gonna take.
Okay, so you can ask him that, and you don't need to put anything on the record in that manner in front of the jury right now, in your closing or when you're cross-examining Detective Sluss. But I'll let you ask the question again, and you are free to answer it over the preserved objection of counsel for Mr. Reynolds.
Yes, Your Honor.
Investigator Sluss, in your experience, how long would it take for someone to travel from where the phone was around 10:06, 10:08 in the morning to where the phone was located at 11:06? Would it take an hour?
Depending on traffic, I mean, it could take anywhere between 15 minutes to, no, I don't think it would take an hour. Unless there was some kind of, and again, I don't know the traffic, what happened that morning, but generally it would not.
Would it take, because the phone actually traveled back from that area back to Harwell Place and then to Children's Healthcare of Atlanta within an hour. Is that a fair statement?
Yes, ma'am, it's a fair statement.
So maybe about half the time to get from that location to Children's Healthcare of Atlanta?
That's a reasonable answer.
All right, thank you. I'll pass the witness.
I just want to go over a couple of things there.
It's good to see you again, sir.
Oh, yeah, I haven't seen you for a minute since
Yes,
you went to Homeland Security. Used to see you all the time when you were with Homicide.
Yes, sir.
You ever been going somewhere in Atlanta and there's a lane closed?
Absolutely.
Every now and then you're traveling in Atlanta and
There was a wreck on the way to court here today, sir.
Okay, and has there ever been any accidents in Atlanta?
Oh, of course.
Okay, and does an accident slow you down?
It can, yes, sir.
Or a road closure slow you down?
It can, yes, sir.
What if your car's on empty and you need to stop to pick up some gas, or you need to go pick something up somewhere?
Yes, sir, that's plausible.
Okay, so if you have to make a stop along the way, that could affect your time.
Yes, sir, it can.
Okay, but back to the record. So, and I was doing my best to write. You've always talked fast.
I apologize. I get a little excited sometimes.
Okay.
In my area of what I do.
But that's okay. So the first call is sometime in the morning and he's in the cone at, let's say, 8:41 a.m. He's in the cone for the Harwell place.
Yes, sir.
Okay, and just to describe the cone in a way that I understand it is, I think of it as like an ice cream cone. It's a cone.
Can we call it pie? I love pies.
Okay, we can do pie.
All right, we'll
it's
do
a
pie.
piece of pie.
Okay.
And somewhere in that piece of pie, there's a blueberry.
Yes, sir.
And you can't really say precisely where the blueberry is within the piece of pie.
No, sir.
And you're just going to take a bite of it and, oh, there's the blueberry.
Yes, sir.
Okay, so he's somewhere in that cone, and within the cone for 8:41 is the Harwell place.
Yes, sir.
Okay, and then he starts to move, and it appears that he goes to a petro center.
Yes, sir.
Is that a place where you can like put gas in your car?
It is, sir.
Okay, so it's possible he went to the area of this petrol center to put gas in his car.
Yes, sir.
Or maybe get a whatever they sell there, a Slurpee, a big gulp or something.
Sure.
Okay, or maybe a biscuit or
Sure, absolutely.
one of those.
I don't know if I'd eat there, but I
Okay.
mean, you're more than welcome to.
Okay,
try.
so he goes there. Then now he's headed for the Greenbrier area, is that correct?
Yes, sir.
And he ends up in Egan Park in East Point.
Yes, sir.
And is that near the McDonald's where he worked?
That I don't know. I don't know exactly where he worked. I'm here to kind of give you an idea about, hey, this is where the device was operating at this given time. So
Okay.
what I want you to do is I want you to be able to take the information that you already have and then the timeline that you already know based on previous evidence. And I want you to stick that cell phone analysis on top of it as kind of like a corroboration of what you either know or what might not be there.
I just asked because on direct, the state mentioned the word McDonald's, so I wrote it down.
Yes, sir. There is a McDonald's there. I do know that for a
Okay.
fact.
Now he seems to be moving around Atlanta, traveling around and making phone calls. Is that correct?
Yeah, so like the next thing that happens is like he opens up his Uber app again. So we're to get not just general information where the device is. Now we get specific information where the device is. So we know that he's traveling down 85 based on the data plots and then turns on to 285. And then after he shuts that app down, we're back to, hey, we're in general area of where phone calls are being made.
Okay. So he's just moving around and making phone calls.
Yes, sir.
But we really don't know what he's up to.
Couldn't tell you. I can just tell you the device is interacting with the network and this is the area that it's interacting with.
But there may have been a method to his madness. There may have been something he was trying to do.
That he would have to tell me, but other than that, I'm sure there might be. Yes, sir.
Okay. But we don't know.
No, not until he explains it. No, sir.
Okay. And you do know he's not under a duty to explain anything. In this
That's
area.
correct, sir. Yes, sir.
Okay. You can,
Again, so let me preface that. I didn't interview him to get specific information.
okay, but you do know that you've done this long enough to know that he doesn't have to.
Oh, absolutely not, sir. No, sir.
Okay, but something's going on that we don't know what it is.
Yes, sir. I'm just telling you how it's interacting with the network.
Okay, and then at 10:06 to 10:11, he starts to move. Is that correct?
From 10:08 to 10:30, we're talking about him moving and operating south of the city, Forest Park and Wexwood and Kenwood Park.
Okay, but then at some point he starts to move and he starts moving towards Harwell Place.
That's correct.
Okay, and then he ends up at the Children's Hospital of Atlanta.
That's correct, sir.
Okay, and during that time frame, he definitely goes to Harwell Place.
I can't tell you that he goes directly to Harwell Place. He's operating off the tower that would service 208 Harwell Place. I can't tell you specifically where he's at. I'm just saying his device is in the area of that particular location.
Well, if other witnesses testified that he did in fact go to the Harwell Place apartment to get a jacket, that would be consistent with your cell phone records.
Yes, sir. So the cell phone records would corroborate that particular witness statement.
Okay, so your cell phone records confirm what I'm going to tell you is other testimony that between 10:08 and the time he arrives at Children's Hospital of Atlanta, he did in fact go to the apartment and got a jacket and left and then went to the hospital.
So, all right. So the way that I would answer that question, if you told me that story and asked me to look at the cell phone records, I would say that would corroborate that witness's statement.
Okay, for whatever reason, he wanted to get that jacket, but we can never know what that is.
That has nothing to do with the cell phone records. I can just tell you where he's operating at any given time.
Okay, now understanding that there was something at Harwell Place, his jacket that he wanted to go get before we got to the hospital, would now the timeline make sense that it would take about that long to go from where he was at 10:08, go to Harwell Place, get the jacket, and then go to the hospital. Now, does that make sense as far as time travel through Atlanta?
At that particular time, I can't say specifically, but generally speaking, you know, if it takes you 20, 30 minutes to go from one place to another to Harwell Place, it would be an acceptable answer, but I can't tell you specifically it's 11 minutes or it's 22 minutes.
And then another 20 to 30 minutes to get from Harwell to the Children's Hospital in Atlanta.
Right. I mean, I'm telling you how his devices travel.
So your cell phone records make sense with the fact that on the way to the hospital, he stopped off at Harwell to get his jacket.
That, I don't know what he did. I can just tell you his device is operating off of that tower that was service 208 during that time. And what he did during that time, I can't tell you.
Okay. All right. All right. Thank you very much.
Thank you very much, sir. Good to see you again.
Ms. McCauley, any redirect?
Just briefly, Your Honor. So Detective Sluss, just based on your report and your analysis, the phone is at 10:08 south of the city, almost near the Riverdale area.
That's correct, ma'am.
Does not travel back to Harwell Place until near Harwell Place until 10:46,
That's correct.
and then goes to Children's Hospital of Atlanta at 11:09.
That's correct.
All right, nothing further.
Mr. Shepherd, anything else?
Yeah, and is 10:08 to 10:46 consistent with the amount of time it would take in morning rush hour traffic to get from south of Atlanta to Harwell?
That I don't want to speculate because on any given day, it could, like I live up in near Kenisha. It could take me 45 minutes to get to work and it took me an hour and a half to get to work.
But it's within the margin of error.
Again, I don't want to speculate and I don't want to missay anything to the jury.
Okay. Thank you.
Yes, sir.
Questions from the jurors for Detective Sluss? You write them down. Deputy Gordon will collect them. Thank you. Detective Sluss, are you able to tell from the records that you examined if in that window you looked at from 10:08 to 10:31 or whatever the times were, you know what you were looking at, if there were multiple calls to the same number or from the same number? So we've been talking about the device associated with Mr. Reynolds. Are you able to say, hey, he called a number ending in 1, 2, 3, 4 6 times out of those 31 calls?
I didn't memorize it itself. If they want to give me the records, I can sit there and look through them quickly.
Is that something that is easy to put up or not easy to put up?
So it's not necessarily easy to put up. I think that the detectives will answer that question.
Okay. Question for another witness. Understood. All right. Based on that question that has been deflected and deferred, do you have any follow-up, Ms. McCauley?
I don't know.
Mr. Shepherd? All right. Thank you, sir, for your time. Appreciate it. Same. All right, Ms. McCauley, any more witnesses today?
No, Your Honor. All my witnesses will be here.
All right, and this was one of your Monday witnesses that you were able to reschedule. Thank you for doing that. So as forecast, we're ending a little early. It's almost 3. I'm going to pretend it's 3. The state has 1, 2, 3, 4, 5 witnesses left, most likely. Things can always change, but 5. And they will all be available on Monday. We'll see how many of them we get through. Some of them will be testifying for longer than a bunch of the witnesses that you've encountered so far. But we remain, it sounds like, on track with the state's presentation. I'm going to ask you all to be here by 9:30 on Monday. The state's witnesses are going to be coming in as soon as they can, but I don't want to get you here at 9 and we can't start till 9:30. So if you could be here by 9:30 on Monday, we will dive right back into the state's case and press forward for the rest of Monday with all the usual breaks that we take. This is going to be a whole weekend when you're not here, and that's okay. Don't talk about the case with others, no outside research. If you've got questions, you write them down and we pose them to the witnesses and they give you the answers here in court. Any logistical questions? We'll start with the front row. Yes, ma'am.
Are we not in a different room?
Ah, right. Thank you for reminding me. We are. Our itinerant existence continues. We're in 8A, Alpha, 8A. And you'll be there. That's the only other room you're going to need to learn. We are in 8A. I am in 8A. Longer than this trial will go next week. So thank you for asking that. That jury room will be ready for them. We're going to make sure that the little white basket of goodies relocates to 8A. So same building, 8th floor, all the way down. Exciting, your jury room has windows. The A's and the F's, windows in the jury room. So if you photosynthesize, that's part of how you get energy. You don't need to bring lunch. Just stand near the window. The sun will take care of it. That's a treat. Judges jockey for A and F. I didn't get it. So 8A. Any other questions, or did that all the hands go down? Yes, sir.
We still leave our notebooks.
Yes.
Should we put our names on it?
If you want to, that's fine. We will take them up to 8A. Like I said, that basket, I don't know if we supplied water, we'll take our waters. Everything that we brought down to make your jury room as cozy and hospitable as possible, that wasn't already there. We'll move to 8A. So your pads will make it. Do not take your pads home. They'll just be sitting in a stack on the table in 8A. Anything else? So 9:30, Monday, 8A. Do you have the chamber's phone number to call? Call that if something comes up and you're going to be 9:45. If you're going to be 9:31, you don't need to call. But at 9:32, we start worrying. This group hasn't had an issue. Usually in each jury, juror, I'll say number 99. We figure out real quickly 99 is just never going to be on time. And so we're calling, where are you? You guys have been great, but call us if you encounter one of the inevitable that makes it hard to say. How long does it take to get from Harwell Road to Choa? I don't know. It depends if the lanes are closed, if a plane landed on the freeway or whatever the deal is. If we don't hear from you, we assume everything's fine. And then if you're not here, we get confused. Okay. Anything else? Thank you for your service thus far. Have a good, slightly longer than expected weekend. And we'll see you Monday morning.
All right, for the drill.
All right, you all can be seated. Ms. McCauley, thank you for sketching out how Monday might go. Do you think that you now have a pretty good feel for Mr. Shepard's crosses and their extent and duration? Do you think we'll get through everyone on Monday, barring an unforeseen whatever?
Yes.
Okay, all right. Anything else we need to cover from the state?
Okay, I'm just looking at a bunch of emails that I got while I was sitting here in the room with y'all.
Right, while you read those, I need to talk to Mr. Reynolds for a moment. Mr. Reynolds, it may be Monday, my guess is it will be Tuesday, but either on Monday or Tuesday, the time will come where I ask you, I don't ask Mr. Shepard, I don't ask anyone else in the room, I ask you whether you're gonna testify or not. That is a right that is unique to and exclusive to the defendant. So it is A-okay for you to consult with Mr. Shepard or your mother or anyone else, but in the end, Michael Reynolds decides if he's gonna testify or not testify. And there's some questions I have to ask you about your rights and making sure you understand the consequences of choosing to testify. The main one being, you don't just get the easy questions from Mr. Shepard, you get complicated questions from the state. But also your right not to testify, your right to remain silent. And so in the end, at the end of that conversation, I'll say, all right, Mr. Reynolds, do you want to testify? And there are two options. You say yes or you say no. What doesn't work is for you to say, dang, I haven't had enough time to think about it. That's why I'm flagging it for you now, so that over the weekend you can think about it. You can continue to discuss it with Mr. Shepard. talk about it with friends or family members. But at some point, either late Monday or early Tuesday, we'll reach that crossroads. The state will have rested. And when the jury's not around, I don't ask this in front of the jury. They don't get to hear that at all. I ask you if you're gonna testify or not, and you'll need to let me know that answer, okay? All right, any questions about that? All right, Mr. Shepherd.
Yes, we've already been discussing that issue at length all week. He's gonna make
He's not announcing now, don't worry. He is, you get to keep until the last second. You may hear some things from witnesses on Monday that convince you, you better testify, or convince you, I need to stand 100 miles away from the witness stand. So Mr. Shepherd is not about to commit you. He can't. I'm not gonna ask him whether you're testifying. I'm gonna ask you whether you're testifying. So let him finish his part, but don't worry, he's not about to jump out ahead of things. All right.
So to finish, we've been talking about it for a while, and he's informed me that he will be ready to make his decision on Monday.
Good.
The state rests.
Perfect. That's all I need to know.
It's not gonna ask for more time. It's not gonna do anything to delay or slow down the trial, but we've talked about it, and he will be ready to make his decision on the time.
Excellent. And me bringing it up is not pressure in any form. It's me just letting you know that discussion that you and I will have is right around the corner. Not tomorrow, not Sunday, but maybe late Monday or possibly early Tuesday. Okay. All right. I don't have a draft charge for you all yet. That will probably pop out on Monday. We'll need to have a charge conference. I don't think it should be a particularly complicated charge in this case, but we will see. If there is nothing else, then. Oh, yeah. I'm sorry. I thought you had gotten through that. Keep reading.
I'm gonna keep my opinion about how much I love or hate email to myself.
I'm sorry. I didn't want to interrupt.
I'm gonna set up a 12-step program for email addicts. It looks like the whole important of this is that we're gonna start at 9:30 instead of 9.
Correct, which I already announced to the jury. So that's it.
And the last thing is that I decided I am gonna shut up all this stuff all the way home and all the way back on Monday, that rather than have to inconvenience somebody and say, oh, can I put this in here till Monday? It's not that much. So
Okay.
get this stuff all the way home.
Okay.
And then bring it back all the way Monday by 9:30 a.m.
Great. In 8A.
I love that courtroom. I want a murder trial with Judge Goder in there once.
All right. Well, we'll see if that karma still is swirling in 8A. I will see everyone in 8A a little before 9:30, and I hope that the prosecutors will continue to color coordinate their outfits.
Oh my God.
It's synthesizing. I don't think YouTube likes us in matching outfits, but it's fine.
Hey, man, congratulations. You sound like a good promotion.